Yes, sir.
349.
Yeah, because I know College Park is 4.9. And I know a lot of Southwest is 30311.
I can look up the address,
I'm doing
I mean,
it
the
now.
zip code if we've got the rest of the address.
I got it. I'm doing it.
Okay. Whoops.
Okay. It's still one ended in one. We got it. I got it. I'm sending it to him.
All right. Good afternoon, Ms. Rivers. Are you ready to go?
Yes, I am. Good afternoon.
Good afternoon. We are, let me close this. I don't understand what this is. Oh, yeah, okay. All right. We are here on 22 SC 185545. We have Mr. Lemons out in court with his lawyer, Ms. Cabrera. We have Mr. Abate here for the state. Mr. Lemons, it's my understanding that you are prepared to enter a plea in your case. Is that correct?
Yes, sir.
Okay. Mr. Abate is going to put you under oath in just a moment. He'll ask you a bunch of questions about your rights. I may have a few questions. You may have some questions. I need to make sure you let me know if you have any questions. Will you do that?
Yes, sir.
Excellent. Then let's get started.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give in the matter pending before this court will be the truth, whole truth, and nothing but the truth, sir?
Yes, sir.
Hey, put your hand up. Could you please state your true, correct, and legal name for the record?
My name is Eric Lemons.
And
They posted it
Oh,
so she
sorry.
can hear you.
Eric Lemons?
are you at this time taking under the influence of any alcohol, drugs, or medicine?
No, sir.
Is there any medication that you take on a daily basis or regularly that you've not taken today that would affect your ability to understand why you're here?
No, sir.
Okay. And how old are you, sir, and how far have you gone in school?
I am 32 years of age and I graduated from high school and I have a college degree.
Okay. And
Where'd you go to college?
I went to Voorhees College in Denmark, South Carolina. It's a HBCU.
All right. And what is your degree in?
Business management.
Okay.
And are you able to read, write, and understand the English language, sir?
Say that again, sir.
So are you able to read, write, and understand the English language?
Yes, sir.
No. Do you understand that in indictment number 22 SC 185545, you're charged with count 1, murder. Counts 2 and 3 are felony murder. Counts 4 and 5 are aggravated assault counts. And then count 6 is concealing the death of another. Count 7, the last count is tampering with evidence. You understand that?
Yes, sir.
And do you understand that you have the right to plead either guilty or not guilty to these charges? And if you pled not guilty or remain silent, you may receive a jury trial.
Yes, sir.
And have you spoken with your counsel, Ms. Cabrera, about the reduced charges that you'll be pleading guilty to as it relates to this indictment and the counts I just read?
Yes, sir.
And is it your understanding that counts 1 through 5 would be null pros or dismissed, and then you would be pleading guilty to counts 6 and 7?
Yes, sir.
Okay. And have you gone over the rights that you'd be waiving with Ms. Cabrera in the previous opportunities that you've had to speak with her? Yes, say yes. Or no.
Yes, sir.
Okay. And have you had enough time to speak with Ms. Cabrera about all the facts and circumstances related to this case and the plea that you are entering into today?
Yes, sir.
And are you satisfied with the services that she's provided?
Yes, sir.
Ms. Cabrera, do you waive formal reading of the indictment?
So wait.
Do you also waive any and all defects in the indictment, including any with respect to your client's name for the purposes of this plea or hearing?
Yes.
Okay. And Mr. Lemons, has Ms. Cabrera advised you of the minimum and maximum sentence for the charges that you're pleading guilty to?
Yes, sir.
And she advised you for both concealing the death of another and the tampering with evidence. The minimum is 1 year, the maximum is 10 years.
Yes, sir.
Okay. Do you have any questions as it relates to those charges and then the minimum and maximum sentence?
No, sir.
Okay, and do you understand that this is a negotiated plea of guilty which means the state and Ms. Cabrera, your counsel, will make a joint recommendation to the court as it relates to sentencing, but the court does not have to follow the sentence that is recommended and can sentence you as he sees fit, meaning that he can sentence you consecutively for each count you're pleading guilty to, which means he could sentence one after the other. So 10 years plus a consecutive 10 years would be the possible maximum. You understand that?
Yes, sir.
Okay. And do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including the federal courts?
Yes, sir.
And do you also understand that if you are not a United States citizen, a guilty plea will affect your immigration status and will result in deportation, regardless of any advice given to you by your attorney, Ms. Cabrera, or anyone else?
Yes, sir.
Okay. Do you understand that you waive any and all defenses by entering a guilty plea here today?
Yes, sir.
And do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, to not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or court appointed if you are unable to afford an attorney at the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and to compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt by the state of Georgia, and the right to appeal if convicted of these charges after trial. You understand that you're giving up or waiving all of those rights by entering a guilty plea here today, sir?
Yes, sir.
And has anyone forced, threatened, or promised you anything to get you to enter a guilty plea here today?
No, sir.
And is it your decision to waive these rights and enter a guilty plea because you're in fact guilty of the two counts, counts 6 and 7?
Yes, sir.
And how do you plead to the remaining counts, so counts 6 and 7 in indictment number 22 SC 185545? Count 6 is concealing the death of another. How do you plead?
Guilty.
And as it relates to count 7, tampering with evidence, how do you plead, sir?
Guilty.
And is this guilty plea, Mr. Lemons, freely and voluntarily given with full knowledge of the charges against you, sir?
Yes, sir.
And do you understand that you may only have a limited right to appeal this guilty plea conviction from today?
Yes, sir.
And have you gone over, you had an opportunity to speak with? I believe.
I just want to make sure something was fine.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging this guilty plea, sir?
Yes, sir.
Okay, and do you have any additional questions as it relates to what you and Ms. Cabrera have previously spoken about that a habeas corpus petition entails?
No, sir.
Right. And from my review of your criminal history and from speaking with Ms. Cabrera, are you asking the court to sentence you under the first offender provisions of the First Offender Act?
Yes, sir. That's correct.
And have you ever served, pled guilty, or nolo contendere to, or ever been convicted of a felony in the state of Georgia or any other any other jurisdiction?
No, sir.
And have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No, sir.
And have you had an opportunity to ask any questions and have the First Offender Act fully explained to you by your counsel, Ms. Cabrera?
Yes, sir.
Do you have any questions about it?
No, sir.
You understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, that your first offender status could be revoked, sir. You could be adjudicated guilty, and you could possibly be resentenced up to the maximum sentence for each charge that you're pleading guilty to in this indictment.
Yes, sir.
Okay. Do you have any questions about that as we move forward?
No, sir.
Okay. Your Honor, had this case proceeded to trial, the state would have provided evidence that on September 26th of 2022, at approximately 3:00 a.m., Mr. Brian Gaspard, Gaisford, was found deceased in room 346 at the Economy Lodge Hotel at 9995 Old Dogwood Road, Roswell, Georgia, here in Fulton County. Mr. Gaspard was found deceased by two employees who were cleaning the rooms, getting the hotel rooms that remained for the next day. Ms. Brianna Walmsley was the individual who called 911 as her coworker Mallory Thompson was by her side. At that point, upon the calling of 911, the Roswell Police Department was dispatched to the location. The officers and then eventually crime scene techs or individuals arrived to process the scene. As they began to process room 346, where the victim was located, shirtless with his pants down towards his ankles or knees, as it looked at he had been dragged from a room into 346. He was wrapped in a sheet that didn't fit the bed that was located in room 346. As the officers began to investigate and the surrounding areas, they were able to see inside an adjacent room, room 344. They saw that there was a sheet that was hanging over the window that would allow you to see inside the room. There was an area of the window that was not covered, and as they walked by, they could see that the room was in disarray, and they could see that what appeared to be blood was all over the room. They then applied and then executed a search warrant for that room, room 344, which they were able to determine was rented by Michael Ryder on September 3rd, and he was scheduled to remain in that room until October 1st of that year, 2022. Upon entering the room, they began to process what they believed to be the crime scene where Mr. Gaspard was beaten to death, as it related to his injuries and what they believed to be missing evidence from room 344 that had been taken into room 346, or where the victim was found. They processed the scene for DNA as well as fingerprints. Eventually, the DNA was sent to the GBI, where the victim's blood was found all within the room, room 344, where the beating had occurred, as well as fingerprints for this defendant, Mr. Lemons, and his co-defendants, Mr. Ryder and Mr. Hardy, as well as Mr. Robinson, were found in both rooms, room 344 and 346. A further investigation from the detectives with the Roswell Police Department, they were able to find video surveillance footage for the motel. The surveillance cameras were not of the clearest quality, but they were of quality where you could identify individuals who were in close proximity to the cameras. Through the investigation and looking at the video, they were able to identify Mr. Lemons as somebody who worked at the property, and in speaking with members of the staff, as well as Mr. Lemons, eventually upon his arrest and after being Mirandized, agreeing to speak, he did indicate, as well as other employees indicate, that the occupants of room 344, that included Mr. Ryder, had requested cleaning solutions such as bleach, and I think Fabuloso was one of them, to clean, and extra towels and trash bags. And from speaking with Mr. Lemons, the detectives were able to identify the other parties involved in this incident. Mr. Lemons did admit to helping conceal and get rid of evidence such as sheets, towels, things of that nature, as he was a member of the staff for this hotel. And he further was able to provide the detective that a statement that was made to him by Mr. Hardy. And later that evening, after they finished cleaning what they classified as cleaning of the room, he approached Mr. Lemons, he being Mr. Hardy, and said that they had to do that to the, I guess the exact quote to the detective was, they had to do that to the baby. Mr. Lemons looked at him strangely and said, "What do you mean?" He said, "We had to do that to the white guy. We had to beat him up. We learned he was an informant." And that's what Mr. Lemons provided to the detectives upon his arrest. I believe that was on October 6th of 2022. Mr. Lemons has been in custody, or remained in custody since that date. I believe he's been in custody for 1,010 days, so roughly 2 years and 9 months, to my calculation. The state and the negotiation between the state and defense counsel is that the defendant received a sentence very similar to the other two defendants who pled this morning, a 10-year to serve 2 years and 9 months in custody. He will be released on the time he is served. And then he, as a condition of his sentence, would be required within a month of his release to sit down and make a statement, a formal statement with the district attorney's office, as well as testify truthfully if and when he is subpoenaed to testify against the remaining defendant, Mr. Ryder, who is believed to be the individual who primarily did the beating of the victim. And nothing further from the state.
All right, thank you.
And while your honor's looking something up, I will also say that Mr. Lemons was arrested that same day. He was actually arrested that same day for an unrelated offense. It was an aggravated assault, I believe, that occurred on that property earlier. That aggravated assault has since been, from my understanding, looking at the docket, it was MPGJ or the district attorney's office, unrelated to me or this case,
Okay.
had elected to not prosecute.
All right. I was looking to see if we had anyone from pretrial on. We don't. I just want to confirm Mr. Lemons's eligibility for first offender. Ms. Simpson, do you have any information that would show that Mr. Lemons has ever been on probation in Georgia?
No, Judge, he's not in our system.
Okay, thank you. Well, I'm going to take you at your word for that. I found a few arrests, but they were either for misdemeanors or didn't result in anything. So we'll see where that plays.
In one other case from 2013, and what I actually was just able to review, it was a theft by, I think, receiving or deception. It's a felony charge, and it was here in Fulton County. He was indicted, but ultimately he received pretrial intervention or
Okay,
some sort of program like that.
got it. All right, Ms. Cabrera.
Well, he stole my thunder. He already talked about himself. But we've been working on this for a long time. He has been cooperative from the beginning. And he's got family support. They've been supportive the whole time. He's been incredibly patient with the process. Obviously, we've been on the calendar a couple of times thinking that we were doing something and it didn't happen. Given what he's already told you about himself, I think, and him not having any prior criminal history, I think that he's going to successfully complete probation. I think he's going to successfully complete first offender treatment. And I'd ask that Your Honor accept his plea as negotiated.
All right. Mr. Lemons, do you have people here in court with you today?
Yes, sir.
Tell me, you don't need to give me names, but is it friends, family members, just a fan base?
Family member. I have my wife and both of my cousins.
Okay. How long have you been married?
I've been married for 12 years.
So you've been away from your wife for almost 3 years now.
Yes, sir.
Okay. Any kids?
I mean, hers is just like mine.
Sure. So how many kids are in the household?
It's 3.
And what are their ages?
One of them is 14 and the other one is 21 and the other one is 19.
Okay. So mostly grown up, but you got a teenager.
Yes, sir.
All right. All right. And what is it that you hope to do in terms of work when you get out?
I'm going to do warehouse work. I have an actual job in store for me when I get out of here.
How is that?
Guaranteed. What I have to do is like they do landscaping and they do warehousing.
But how do you've been in jail now for almost 3 years. How do you have a job lined up for when you get out?
It's just a record. Somebody recommended me, so I just have to fill out the application.
Got it. Okay. Well, it sounds like folks are working hard on your behalf on the outside. Here's what I really want to know. That stuff is important, and I'm glad you've got family structure, and hopefully kids and wife are an inspiration for you to make better choices going forward. How did you get wrapped up in this? Did you know these guys, or they just said, hey, we'll give you $100 if you throw away these bloody towels? I mean, you had to know this dude's dead on the ground and he was beaten to death. It's not we slipped some poison in him and he's sleeping. So tell me how you got mixed up in this.
Well, actually, Your Honor, I was just doing my job, and I was just instructed to do like what any residents they tell us if they need trash or cleaning supply. Then
If they there's a dead body in here, come help us move the dead body to another room.
Wasn't nothing being verified about no body or a murderer being aware. They were just saying that they need cleaning supplies.
Okay, in a room that had blood all over it.
Yes, when I stepped in, I didn't see no blood. That's why I didn't draw anything to make a report, because I didn't see nothing that would draw a red flag for me to make a
And you can
report.
tell judges you know them.
Yeah, I mean, I don't know them because of the property, but yes, I just know of.
Meaning they frequented the property.
Yeah, they resident. They stayed
And
on
it
the
would
property.
come out that these are people that he has smoked with,
Yeah.
that he is.
Okay, all
That's
right,
right.
so that's all I'm getting at. It's like you knew these guys,
Yeah,
and
I
so
just
when
know-
they
yeah.
say, hey, Lemons,
You're gonna
okay,
have
yeah.
to say so
Okay,
eventually, so.
Yeah. Well,
and so this is sort of a dry run, because you're helping me understand.
Okay.
If you knew nothing about them and nothing about this, Ms. Cabrera would have gotten you out earlier. I know that,
right.
because I know how she works, and she would have been making Mr. Abate do the right thing. So you knew these guys, and you knew there was probably something funky going on in that hotel room.
Yes, sir.
Okay, that's all you need to share with me. You've been the one disconnect. I understand the other three guys, how they're interconnected and what happened and all that. But because I don't get to talk to you with your lawyers not sitting right there, and the prosecutors in the room, I've been trying to figure out your connection to it. So they knew you worked there. They didn't just call any random help guy when they needed this situation. They didn't call the front desk, hey, bring a mop and a bunch of blood mopper-uppers. They knew reach out to Lemons because he'll be quiet about it.
Yes, sir.
Okay, all right. Mr. Lemons, do you have any questions for me?
No, sir.
All right, anything more you want to add?
No, sir. That'll be all.
Okay, well, I find there's a factual basis for your plea, in that your plea is knowing and voluntary. Knowing means you've understood everything we talked about. You told me you don't have any questions. Voluntary means no one's forced you to enter this plea. Do you agree with that?
Yes, sir.
I'm sentencing you pursuant to the Probation Options Management Act. That means that while you're on probation, which you will be for a while, if you have a small problem on probation, you and probation will sort that out. But if it is a big problem, an arrest, you refuse to cooperate with the state, things like that, that comes back to me and I'll figure out what to do about it. Okay. Ms. Cabrera, can someone in my office sign the indictment on your behalf?
Absolutely.
Mr. Abadi?
Yes, Your Honor.
This is Mr. Lemons. Is it okay if we sign your name electronically to the indictment indicating your guilty plea to count 6 and 7?
Yes, sir.
We'll do that. The other counts are going to be dismissed on the state's motion. And your sentence as to count 6 is going to be 10 years to serve 2 years and 9 months with the balance on probation. So that's a little more than 7 years probation. If you do well on probation, they're going to want me to end it early, and I'll do that if you're doing well. If you're not doing well on probation, it's going to drag on, and there'll be revocations, and you'll be away from family for 6 months, and then you'll be back. So I hope that at age 32, having wasted the last 3 years of your life sitting in jail because of these guys you helped out, you're ready to focus on warehouse work, wife, kids, gardening, whatever your hobbies are going to be that aren't hanging out at that hotel with those guys. But you decide that. You're a grown man. I'm not going to be walking by your side saying, don't do that. That's a dumb idea. Same sentence for count 7. The special conditions of your probation are, number 1, that you testify truthfully if you are subpoenaed to come to court in connection with this case or a new version of it. It may be that it gets reindicted. You won't be involved with it directly. And the second condition you actually have to satisfy in the next month. Within a month, you need to sit down at the DA's office, and if Ms. Cabrera can be there, she'll be there. If you wanted to be there, she will be there, so it won't be right away because she's in trial. And you are open and candid with the prosecutor about what this case is all about. So you do a little better job than you did with me. Like, nah, I didn't know anything. You're going to talk about what happened. And that is it. When you get out, what county are you going to live in?
South Fulton.
So Fulton County.
Yes, sir.
All
Fulton
right.
County.
Then Ms. Simpson, who is on this call, and you heard her tell me that you're not on probation anywhere. She's with probation. She's going to give you reporting instructions. The most important date you have when you get out is give your wife a big hug. Second most important is to show up at the probation office when you're supposed to. Because if you don't, they send me a warrant. Like, all right, Mr. Lemons, you're off to a bad start. Let's try again. Let's do a few months in jail, and let's try this again with you plugging in with probation. So do not miss that second most important date, okay?
Yes, sir.
All right, Ms. Simpson?
So, Mr. Lemons, your reporting date will be July the 18th. That is next Friday at 9:30 a.m. you're going to report to the Atlanta Probation Office. That is 276 Memorial Drive, Atlanta, Georgia, 30303. I have already emailed your attorney your report instruction sheet so that she can get that information to your family.
Okay, thank you.
Thank you.
All right.
Ms. Cabrera, you have a way to get that to the family?
Yeah, I'm gonna make sure I do it before I get out of here. I'm just forwarding them the email.
Excellent.
The attachment, and then
Good.
you guys make sure that I get it back, and I make sure that she has it.
Okay. All right.
Yeah.
Mr. Lemons, good luck with things. It's been a long journey.
Yes,
It's
it
a new
has.
chapter, okay?
Yes, sir. Thank you.
All right.
Blessed day.
Mr. Abadi, thank you for your time. Sorry to drag you back here again. So we're bringing Ryder over on Monday. I mean, you need to show up, but I mean, he's going to be here and Ms. Feely's going to be here, and is it trial, not trial? So you'll just need to make official. You can be an announcement that you make Monday morning. But that'll be what I have to call before I turn to Ms. Davis to call her stuff. All right. Sounds good. Have a good weekend. And you're still good with Dennis for the second week?
Yes.
All right.
Real quick. I was worried that I disappeared. No, I've got it. Thank you. I'm worried. Thank you. Your Honor, I think last time you told me how to make this screen work.
What's on it now?
You.
Deputy Gordon's going to help you out. Oh, it's not attached. I can do that.
Okay.
If it's me,
It's your silver frame.
yeah, we'll get me off the screen in just a minute. All right. Let's add the podium. There we go. We can remove that.
Okay, so I think we'll be all right.
Judge, will you need the calendar?
Pardon me?
Will you need me for the calendar?
No, I can't. It sounds like you're vacuuming, but you're free to go back to vacuuming. We do not need you for this. Thank you.
That noise is not coming from me, Judge.
Okay. Have a great weekend.
Thank you. You too.
Bye-bye.
I'll sit with him.
It is working out. Thank you very much. It is Miss Rivers, the court reporter today.
Yes. Oh, I think that's coming from Mr. Singleton. So you're good, Mr. Singleton. I'm gonna mute you for a second. All right. That's where we're getting the vacuum cleaner.
I'm gonna go eat peanuts.
Take them all. They're yours. You've got a tab. We're keeping track. Oh, before we pivot to Mr. Singleton, Ms. Bernard got a little emotional partway through the plea. Yeah, and Ms. Bumpus said, I'm not comfortable doing it. Well, he did. You hear it all the time. I don't know anything about this case. And Ms. Bumpus is like, I'm not comfortable. He says he doesn't even know what's in the indictment. All right.
He said, it didn't fail. I just had some, I said.
Yeah. So I bumped them to future trial calendars, but when you come up for air, we should just bring them in before those trial calendars. She's the only one left. Ross was good with the diversion, so she's the only one left in that stolen car case. And then the other guy, we should be able to get through, Ms. Britton's co-defendant. He just was playing like I don't know what's going on.
Okay.
So that was it. Thank you for juggling all this.
Thank you.
Uh-huh.
All right, I'm gonna go next door, eat my peanuts. I heard peanuts.
I heard the state's about to rest. Okay. All right. Are we ready to start with Mr. Singleton?
Yes.
Let's get on the record then. Let me do a couple things to make that happen. Out my magic purple paper. All right. This is 00SC09016, State versus Singleton. This is another chapter in the motion for new trial proceedings. And Mr. Hort is here for Mr. Singleton. We have Mr. Armstrong for the state. Mr. Singleton is appearing courtesy of the Georgia Department of Corrections, who remains an excellent partner in communications. He is at the Coffee Correctional Facility at his own request. I have made Fulton County available to Mr. Singleton throughout these proceedings, but his lawyer, Mr. Hort, has told me each and every time that Mr. Singleton wants to stay where he is. So he has watched patiently the many hearings we've had, and it may be that he does some talking today. But I'm going to start with you, Mr. Hort, to let me know what you are hoping to do this afternoon.
Yes, Your Honor, we will be starting with Marvin Dixon as our first witness and then Mr. Singleton.
Okay. Do you forecast getting through Marvin Dixon today?
Yes.
Okay. Is he outside?
Yes, he is.
All right, let's bring him in.
Face me and raise your right hand. Do you swear affirm that the testimony you will give will be the truth, the whole truth, and nothing but truth, so help you God?
I do.
Lord, you're not see. Can you state and spell your name for the record?
Marvin Dixon. Last name is Dixon.
Thank you, Your Honor. Mr. Dixon, would you give us a brief background, work experience history?
I'm sorry?
Would you give us a brief background of your work history experience?
Yes. I became an investigator, private investigator in 1988. In 1994, I went to work for the Fulton County Conflict Defender's Office as their chief investigator. I held that position until 2007. From there, I went to the Clayton County Public Defender's Office, where I was chief investigator. I also worked with a number of criminal defense attorneys in the metro area. If you'd like me to name some of them, I would.
You don't need to. It sounds like you've had a long and illustrious career as an investigator, originally private, and then with some important local agencies. All right.
As the chief investigator for the Fulton County Conflict Defender Office, can you describe for us what were your role, your assignments? What did you do there?
As chief investigator for the Fulton County Conflict Defender's Office, part of my duty was to assign cases to other investigators, and the more complex cases I would take on myself.
Now, is it true that during the Singleton timeframe, early 2000, you're the chief investigator, Gary Gishard is the lead trial attorney, and Carl Greenberg was the appellate attorney? Is that correct?
In early 2000, yes.
Okay.
And Mr. Gishard was the lead attorney for the whole courthouse, or he was assigned to just a few judges?
Mr. Gishard was assigned to all the major cases in the office.
Okay, so if a major case went to Judge X, he followed that. Judge Y, he followed that major case, as opposed to if it was a burglary where they needed a conflict defender, that might be someone who's linked just to that courtroom.
Correct.
Okay.
During this time frame, what can you tell us about your personal experience, interaction with Gary Gishard?
Virtually none.
What do you mean?
Well, Mr. Gishard rarely came to the office, and when he did come to the office, he and I never really communicated.
even though he was doing the major crime cases and you were the major crime investigator?
We never communicated that much.
Okay, did he use you?
He never personally asked me for assistance. Some of the other attorneys that was helping him would come and ask me.
Okay, and do you have anything you can tell us as to why the chief trial attorney for murder cases did not use the chief investigator for murder cases?
I can't answer that. He never asked me to help him with any cases.
Okay, well, what can you tell us about him?
Objection, Your Honor.
Honestly, I
for the
don't
vague-
know.
Stop for a sec. There's an objection.
Overly broad, vague, and irrelevant.
Okay, I'm gonna ask you to focus the question a little bit, but I have a question that's gonna cut in front of yours. Mr. Dixon, you mentioned that Mr. Gashard never asked you for assistance on a case. Since you were the chief, were you ever aware that Mr. Gashard would ask a different investigator other than you to help him with his cases?
No.
And given your role as chief investigator, would you know, or would it have been reported to you by one of your investigators, hey, I just need to let you know, I'm helping Mr. Gashard on this case?
Correct. That would have been the protocol. Yes.
Okay. So your testimony is, one, Mr. Gashard never asked you for assistance, and then two, you're not aware of him really ever asking any investigator for assistance.
No.
Okay.
Did you have any experience working on cases with Gashard inside, outside the courtroom?
I assisted in one case where Mr. Gashard was the lead attorney. He did not ask for my help. The second chair did.
Okay. Would it refresh your memory to look at the statement you gave to our investigator, Mr. Raleigh?
Objection, Your Honor. He hasn't claimed to not know something.
Right. We're not refreshing anything so far. He's
Okay.
answered your questions.
Did you tell Mr. Raleigh that your experience on working with cases with Gashard, both inside and outside the courtroom, was so negative that you avoided working with him for fear that your own professional reputation would be damaged by Gashard's consistently subpar effort as the senior trial attorney?
What I said was, to be honest, is that the one case I did work with Mr. Gashard on, I was very disappointed because in that case, I felt like we found a lot of witnesses that would have been very helpful to his case, and he never called a single witness.
Was that this case, the Singleton case, or some other case?
Some other case.
Okay.
Did you tell Mr. Raleigh that everyone is entitled to proper representation?
Objection. This is refreshing recollection when something, he hasn't testified to not knowing something. It's
Okay.
still there.
Right. So let's keep asking Mr. Dixon questions you think that are going to elicit answers that are things you think he said before, and we'll see where those go.
From your experience with Gashard, did he provide proper representation to his clients?
Objection, Your Honor. That's an opinion question.
I'll allow it.
Based on what I saw, I don't think he did. I really don't.
The case that you were mentioning to the judge without going into details, was that the Gene Gates case?
I'm sorry.
Gene Gates?
That was one of the cases I worked, but Ms. Wardell asked me to assist with that case. If the judge will allow it, I can tell you the case that I did work with Mr. Gashard, and I was just taken aback by his lack of calling witnesses and stuff.
Okay, we won't go into details because the court's already ruled that way. Was that the Michael Lewis case?
That's correct.
What, if anything, can you tell us about Susan Wardell during this time frame?
Ms. Wardell was an attorney as well as a social worker, and whenever she worked with Mr. Gashard on a regular basis, whenever they had complex cases, she would ask me for assistance.
What about so far as working out pleas, her relationship with Sheila Ross, juvenile behavior? What can you tell us about Ms. Wardell?
Would you repeat your question?
Sure. With regards to Ms. Wardell, what about working out pleas, her relationship with Sheila Ross, her expertise in juvenile behavior? What can you tell us?
Objection, Your Honor. Not relevant, and it's about a completely different person than the person who was absent.
Right. So tell me the relevance. I know Ms. Wardell has testified and she's in the room, so we're clear. her performance is not at issue here. So what's the relevance of an opinion, already kind of borderline problematic, of another lawyer's performance, capabilities, et cetera, who was not Mr. Singleton's lawyer?
One, she could have worked out a plea in this case. Two, she had a very good relationship with Sheila Ross. And three, Gashard should have used her expertise in juvenile behavior, either in preparation for the trial or even as a witness at the trial or as sentencing,
Okay.
all of the above.
So number three, I think you've covered through Ms. Wardell, and that's the best evidence on it of how she was not used and her resources were not brought to bear. If you want to explore through this witness, if he knows about the nature of the relationship between Ms. Wardell and Ms. Ross, you can do that. The rest is argument that I'm happy to hear at the appropriate time.
What can you tell us about Ms. Wardell's relationship with Sheila Ross?
Honestly, I have no knowledge of that.
Did you know that Gashard was arrested in 1995 and in 1998 had a criminal conviction in Butts County? Did you know about that?
I found out about it later, yes.
What do you mean by later, like now or approximately when?
An appeal was being filed in the Michael Lewis case. And I was contacted and asked to go down to Jackson, Georgia, to the Superior Courts down there and see if there was any charges filed against Mr. Gashard.
Okay. Remember approximately what year that would have been? If you don't, that's fine.
I'm not sure. It's several years after Mr. Lewis was convicted.
What, if anything, can you tell us about Mr. Gashard falling asleep or dozing off in court?
I've seen him fall asleep in court.
Was that common knowledge in the conflict defender's office?
It was.
Going to the Singleton case, did Gashard ever use or even ask you to work as the investigator in this murder case of a police officer?
No.
Would that have been within your skill level as the chief investigator to work that case, this case?
I would think so.
Did Gashard ever ask you to look at the state evidence relating to the firearms and ballistic evidence?
No.
Now, our investigator now has reviewed this evidence and testified in court.
Objection, Your Honor. Giving him information about what somebody else has testified to is not appropriate.
He hadn't finished. I don't disagree.
But I think the harm will be he's telling the person what this other person said.
No,
That's the
I'm not
question.
disagreeing. He hadn't quite gotten there. So I guess it was a good preemptive strike.
Can I finish my question and then you can go ahead and decide?
Yes, but if the rest of your question was, and Mr., is it pronounced a league? I don't want to mispronounce this. I don't care what's fine. How does he say it?
That's how I say it.
Okay, how you say it?
Am I right? I don't know.
No, well, I'm going to use you. Mr. Alig said that the ballistics was terrible. You've given this witness what another witness said, and then do you agree with that? Or and that's not a space we ought to operate in.
Well, I did not do that, and I don't.
No, you hadn't yet. But I heard it's where the question could have gone.
Yeah.
So if you're telling me the rest of your question isn't, here's what Mr. Alig said, then please do ask your entire question. Then I'll rule on it.
Thank you.
You're welcome.
Would it have likewise been within your skill set to review the state evidence relating to the firearms and ballistic evidence and testify at trial if necessary?
When I get involved in the case, I look at all the evidence, look at all the discovery, and I just follow it whatever it takes me. So if a firearm is in question, I want to take a closer look.
And would it also be within your skill set then if necessary or asked to testify at trial about that particular issue?
It depends. If I'm asked to testify about what I know about firearms, then yes.
Okay. Did Gashard ever ask you to look into any of the expected testimony of any of the state witnesses
In which case?
in the Singleton case? I'm sorry, that's what we'll be talking about now.
No.
Would that be something that you would do in a high-profile murder case?
Yes, absolutely.
Did Gashard even talk to you or have any strategy meeting with you on the Singleton case?
Honestly, I've never heard of a Singleton case until now.
Okay, and is that something you normally would do if you're working with an attorney on a murder case or something that's a semi-high profile?
Oh, absolutely.
Did Gashard ever ask you to look into any of the co-defendants, specifically Michael Waters, who ended up testifying at trial? Did he ever talk to you about that, ask you to look into it?
No, sir.
Would that again be something you would do as the chief investigator or if you were working on a murder case?
Yes.
Did Gashard ever talk to you about the police use of force, pressure on Leslie, co-defendants, anything of that nature in the Singleton case?
Objection assumes facts not in evidence. No one's testified that he was abused by the police.
Response?
I didn't say that it wasn't evidence. I just asked him, did he ever talk to you about?
He, Mr. Gashard.
Right.
Okay, I'll allow the question. Did Mr. Gashard ever ask you about looking into that?
No, sir.
And again, is that something that would be within your skill set as an investigator working on a murder case or maybe any criminal case?
Yes, sir.
What was it like in 2000? Can you tell us what it was like with police officers, use of force, being African-American, a kid, anything you can tell us of that nature back in 2000?
Objection not relevant to this specific case.
Sustained.
You know, and I would make an offer of proof that it is very relevant. That is the one thing that we're going to try to show to this court to get this court to understand what it was
Topic
like.
may be relevant. This witness's perspective on that isn't, Mr. Singleton may end up talking about that, but this witness's perspective on that isn't.
But I'm not asking his perspective. I'm asking what can he tell us about 2000 police officers' use of force,
Right,
black
which would be
kids.
his perspective on that. Let me tell you what I think was happening in 2000. I don't think that's relevant.
From this witness.
From this witness, correct. Not the topic writ large, but this witness's opinion as to what was going on back in 2000 with officers' use of force, et cetera. Unless he then says, and by the way, everything I knew then, I was sharing with Mr. Singleton on a daily basis, so he knew what I knew. But I don't think he's going to say that since he hadn't heard of the Singleton case until you reached out to him.
Can I ask him what he can tell us that's not his perspective, his opinion, but what was the reality of life back then?
That would be his opinion as to what the reality was. So I'd move on to another topic.
Did Gashard ever talk to you about the Clayton County case? And as it relates to Mr. Singleton.
I rarely spoke to Mr. Gashard about anything.
And I realize that we're talking 23 years later. Let me show you what's been received into evidence as Defendant's Exhibit J. A statement from Officer Darren Bell.
Your Honor, this witness has testified he's not seen anything about this case before.
Okay, this is in evidence, so he's looking at a piece of evidence. We'll see what the next question is, but he has said what you said, so that's going to short circuit, I think. I don't know how much is left, but he has said, I do find that Mr. Dixon has said Mr. Gashard never talked to me about the Singleton case. Which is a not unimportant fact. But then asking him, did he talk to you about this? He already said he didn't talk to me about any of it.
And I guess it may not mean anything, but when we talk about the Singleton case, we're talking about Fulton County. So I kind of also wanted to talk about the Clayton County case.
I understand. That's why I'm letting this piece go forward for now.
Thank you. And I'm sorry, I don't mean to interrupt you. Go ahead and take a moment and read through it.
It appears that this is a statement given by an officer.
Yes. And again, I'm trying not to tell you what to say. And I realize this is 20-some years later. And I realize you knew very little, if anything, about the Singleton case. And you probably even don't know what the connection is between the Fulton County case and the Clayton County case. My question to you is, looking through that report, what's in that report? Would that be something within your skill set, your expertise as the chief investigator in a Fulton County murder case to check out what's going on here, reference what this officer is saying?
Well, yes. In a major case, you want to follow all leads, no matter who a witness is. You want to speak to that witness. If they'll speak to you, you just want to do a thorough investigation.
Okay, and again, realizing we're talking about the Clayton County case, related to the Fulton County case, but did Gashard ever ask you or talk to you about the Clayton County case?
No, sir.
Is it sometimes within your work that to maybe to get records from ATF or police department to try to verify information or to see if it's true?
Yes.
And did Gashard ever ask you to do anything about that so far as the Fulton County / Clayton County case?
No.
Were you familiar with Detective Martin, Fulton County or Atlanta Police Department?
No.
Did Gashard ever talk to you about him, ask you to check out Detective Martin, what he said, what he did, anything of that nature as it relates to either one of Fulton County or Clayton County?
No.
And is that something that you would normally do, especially in a murder case? You check out not only witnesses, but police officers, detectives, whatever.
Yeah, I would reach out to Post with a request to see if there's ever been any complaints filed or what the training is. Yes, I would do that.
Now, what about motion to suppress Jackson Dental hearing? You know what I'm talking about? You know what that is?
Yes.
Okay. And is that something that would be within your skill set, the work that you would do as an investigator to help the trial attorney prepare for that hearing? What witnesses need to be called, what questions need to be asked, things like that?
As an investigator working with the defense, I will do a report. I will give my recommendations, and hopefully, we can come to some kind of agreement.
Okay. And again, did Gashard ever talk to you about a motion to suppress or Jackson Dental hearing?
No.
Did Gashard ever talk to you about any possible promises that were made to Mr. Singleton or to his mother?
No, sir.
As the chief investigator, was it also then within your norm that you would talk to the client, the defendant, or family, friends, whatever? Is that something that you would normally do?
Yes.
And did Gashard ask you to do that here?
No.
Bless you.
Thank you. Is it part of your work as an investigator in any case, let alone a murder case, that you are then looking for possible witnesses that could be called at trial or at any motion.
Yes,
I think you talked about that in one of the cases where you found witnesses. Gishard didn't use it.
correct.
Okay. Did Gishard ever talk to you about looking for witnesses in this case?
No, sir.
So just to recap, Mr. Gishard never asked you to do anything at all in connection with Mr. Singleton's Fulton or Clayton cases. Is that correct?
He
Okay.
never asked me to do anything.
Anything. We don't need to go over any other examples of things that weren't done because nothing was done.
Okay. And again, all of this would be within your norm working as the investigator in a murder case.
Yes, when I'm involved doing an investigation, I think it's important and imperative to go back to the scene, to look. One of the things I've learned is, let's say it's in a housing complex. You go in and I know if you see curtains disarray, I know that these people are constantly looking out the windows, so I would go and knock on doors and canvass. Yes.
Was there any other investigator in the conflict office that was doing high profile murder cases?
Have experience, yes.
Oh, and who would that be? Do you remember?
What happened to
So
them?
who would that have been?
Craig Cleveland was one. Craig Cleveland came to us from the DEA. He was also a liaison to the Turkish embassy. So he had a lot of experience.
And so he also could or would work murder cases?
Yes,
Okay. And would it be up to you, then you would assign him to work this case?
correct.
Okay. And is it true, then you did not assign him to work this case, the Singleton case?
Yes.
Okay. Did you ever talk to Carl Greenberg about any of this? Did he ask you what's going on, anything?
No, sir.
No other questions. Thank you.
You're welcome. Mr. Armstrong, do you have any questions for Mr. Dixon?
Yes, Your Honor. Mr. Dixon, good afternoon.
Good afternoon.
I'm going to start near the end. You heard the name Carl Greenberg. Are you familiar with that individual?
I am.
And he worked at the Conflict Defender's Office, didn't he?
Correct.
And he worked on pretrial death penalty cases as part of his work.
And yes,
And you were about to say and. So I just want to, what was the other and? What were you about to say?
and appeals.
So and appeals. So he did more than just appeals. For death penalty cases, are those something that require a lot of attention or a little bit of attention?
Death penalty cases require a lot of attention.
And would Mr. Greenberg put a lot of attention towards those cases in your memory?
I have no knowledge.
Okay.
Of what Mr. Greenberg really did.
Understood.
He didn't ask for your investigative assistance, even though a death penalty case would be a high profile case?
He never asked me for any help.
Okay. And you testified earlier that you were with the Fulton County Conflict Defender's Office until 2007. Is that correct? So when GPDSC, then GPDSC, came into being in 2005, the office still existed and continued, at least for several years, correct?
Correct.
Okay. To your knowledge, doesn't it still exist today?
Yeah, I think they operate a little bit differently. I'm not sure.
Okay. But the whole time that you were there from, I believe you said 1994 to 2007, it was the same office?
Correct.
Okay. There were some questions that were asked of you about ballistics and whether you could testify to it. Can I ask, what type of ballistics testimony have you been presented as an expert witness for?
None.
Okay. I believe I heard you say it phrased this way, but you had never heard about the Leslie Singleton case until these proceedings.
Correct.
Okay. You testified that Gary Gouchard did not ask for your assistance in investigating his cases, correct?
He did not.
Okay. You mentioned at least twice the Michael Lewis case. Is that the case that the book, The Condemnation of Little B by Elaine Brown was written about?
That's correct.
Okay. I'm going to ask you, I'm going to give some information. It's not for the truth of the matter asserted, because I don't think I can call Elaine Brown, but ask you if it's consistent with what you understand Gary Gouchard doing. That book recounts Gary Guichard and Elaine Brown and other people getting into a car and going to look for unhoused witnesses in the bluff themselves on their own so they can find this person because they didn't have a phone number. Is that consistent or inconsistent with how you remember Gary Guichard investigating his own cases?
Can you repeat that?
Yes. So the ultimate question is this consistent or inconsistent with how you recall Gary Guichard investigating his own cases? Basically, Gary Guichard trying to find and contact a streetwalker, I believe was a prostitute, who they had information lived in the bluff or be in the bluff. So gets in a car with Elaine Brown, the author of the book, and others to go and attempt to find this person themselves. Is that consistent or inconsistent with what you recall Gary Guichard doing?
I'm unaware if he got in the car with Elaine Brown, or if he did that on other cases. I don't have any knowledge of that.
Okay, so you don't know what he did to investigate his own cases. You just know he didn't use you.
I do not.
Okay. I believe you testified that he was assigned to the harder cases. Is that correct?
He was.
Do you recall why he was assigned to the harder cases?
It was my understanding that Gary had came to Atlanta from Chicago, and he had a lot of trial experience in the Chicago area, which made him the kind of go-to person with major cases in the Conflict Defender's Office.
Did Gary Guichard try a lot of cases with the Conflict Defender's Office?
I really don't know. I can't answer that.
Okay.
Again, my interaction with Mr. Guichard was very limited.
Okay. How long was he the person who's assigned to handle the harder cases? Do you recall?
How many?
How long a period of time? How many years?
Well, from the inception of the office until I left, Gary was the person.
So you said the inception of the office. When you started there in 1994?
Yes.
That's when the office began?
If memory serves me correct, that's when it started.
I like learning.
96, I'm not sure.
I like learning about Fulton County history. That's why I asked that particular question. So to your recollection, from 1994 to 2007, Gary Guichard was handling the harder cases for the Conflict Defender's Office.
That's correct.
Thank you very much. If I could just have a moment to review my notes, Your Honor.
You may.
You said the name of a defendant, and I did not hear the last name. I believe his first name was Gene. Could you tell me the last name for that individual?
I was asked about Gene Gates.
Gates, G-A-T-E-S?
That's correct.
Okay. No further questions, Your Honor.
Any redirect, Mr. Hort?
Thank you. Is it true that Carl Greenberg only did one death penalty case?
I'm not sure how many death penalty cases Mr. Greenberg handled.
Why did you leave the office?
Why did I leave?
Yes.
It was during the year when we had the housing bust, and I was the highest paid investigator, so they was cutting back.
Did it have anything to do with Gary Guichard?
I'm sorry?
Did it have anything to do with your relationship with Gary Guichard?
Not to my knowledge.
Now, Mr. Armstrong asked you about testifying as an expert witness with ballistic firearms. Would you be able to tell or testify, not as an expert, but what you saw, what you see looking at the state's evidence?
It depends. I'm not a firearms expert, but I went out and spoke to experts about firearms on a number of different occasions.
Okay. Oh, let's do a crazy example. Now, if Mr. Armstrong was to say that Mr. Hort just hit him, would you be able to testify that Mr. Hort didn't even come close to Mr. Armstrong?
Well, when you're using a firearm, I can tell it was close range testified from a distance based on the soot or the stippling. So I
Okay.
can tell that, yes.
Okay, so you would be able to testify as to what you see, what the state's evidence may show, not necessarily as an expert, but what it shows, what you see.
Again, it would all depends, and if I didn't have knowledge then of what I see, I would try to find someone that has the knowledge.
Okay, for example, would you be able to testify as to maybe where the shells were, according to the pictures?
No.
You couldn't tell from pictures?
Oh, well, if I can, if I see photos, I can see, tell certain things about what I see in the photographs.
Okay, and likewise, if there was a report that shows there was blood on a window, would you be able to testify, according to this report, there's blood on the passenger window?
Now, it's a lot of variables in there, so it's kind of hard to say.
I'm not asking what you think I'm asking, I'm just saying, if the state's report, exhibit whatever, shows blood on a passenger window, would you be able to testify upon your review of the evidence there was blood on the passenger window?
Oh, yeah, well, yeah, if blood on, yes, sir.
Okay. Now, what can you tell us about the Lewis case?
The Lewis?
Yeah, the Michael Lewis case.
That was the case. I don't know. I thought I did a great job of investigating that case. I found witnesses I thought was paramount to the defense in that case. None of them was ever caught.
And what about Mr. Gashard? What can you tell us so far as the Michael Lewis case?
I don't know why the witnesses weren't called. That's why I became upset and refused to go back into the courtroom, because no witnesses were being called.
So you were ashamed to even be in the courtroom with him?
I did not want to be associated with him.
Did that include not even putting up an expert witness for the defense? Did that include Gashard not even calling an expert witness?
You didn't call any witnesses that I can remember. Again, I stopped going to court, so I don't know what happened.
So as your work of the investigator in that case, you did interview witnesses.
I did.
And are those the witnesses you referenced earlier that you found that Gashard didn't call, even though they would have been helpful to the defense?
I thought they would have been very helpful.
Thank you, Your Honor.
Any recross?
No, Your Honor.
Mr. Dixon, thank you for your time. I know you were here a few other times and we didn't reach you. So I'm sorry we've taken up so much of your time.
I think it's a pleasure to be in your courtroom.
All right. Well, it's a pleasure having you here. You have a great weekend.
All right. Thank you, sir. Thank you, sir.
You have a good day. It was nice to meet you, sir.
Have a good one. All right.
All right, Mr. Hort, what's next?
Mr. Singleton.
All right, Mr. Singleton, if you would unmute, hopefully they stop vacuuming in your room there and we'll see how you sound.
It was never any vacuum, so I don't know where the sound came from, but hopefully it's gone.
All right. Well, we'll see what happens. We'll give this a try. Deputy Gordon is going to come up to the podium and swear you in, and we'll get going.
You raise your right hand. Do you swear or affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Your lawyer hand. State and spell your name for the record.
Leslie Singleton, Leslie. Last name Singleton, Singleton.
Mr. Singleton, let's start with the motion for new trial. What efforts did you make to have your motion for new trial heard? What can you tell us?
I've try to contact my lawyers. I actually believe we had somebody in, I think I was in Wilcox. I was in one of the prison with, like a prison lawyer who filed a motion, mandamus, something like that, just try to get the ball rolling. I never heard anything about it. Writing letters to the court, writing letters to Greenberg, trying to contact them through family members, and I filed grievances on them as well, so I can get like a new counsel. But I did that twice, but that never panned out.
When you say you filed grievances, with whom did you file a grievance?
I filed a grievance with the, I think it was the bar, whoever was the required, place to file it with. I filed it with them, and then he would in turn call me. The counselor would call me up to the with him on the phone, and he would talk me down and say what he about to do and this, that, but never worked.
Okay.
When you talk about counsel, you're talking about Mr. Gashard or Mr. Greenberg or both or what?
No, whatever prison I was in, like this happened on 2 occasions. After I filed a grievance, I think like the grievance would give him like a warning, I guess. He will contact me and they will call me to the counsel's office to talk to him on the phone.
So you'll be talking to the attorney or to the state bar or?
The grievance was to the state bar or whatever place I was filing the grievance to, but the counselor in the prison would call me to their office to talk to Greenberg.
Okay, so it's Mr. Greenberg that would then talk you out of it?
Yeah, he would tell me, I guess, what I needed to hear at the time to say that, one of the things I never forget was, it's more than one way to win a trial, appeal, and just, he's working and things of that nature, but nothing ever happened.
Okay, let's talk about the delay. How has the delay in hearing this motion for new trial affected you personally and your ability to present the amended motion for new trial?
Why don't we break that into two? Because that can be a long answer.
I think personally.
Okay. The judge wants you to, let's talk about personally first.
For me, it's all personal. I don't even know a way to separate the two, but mentally, you feel me, in regards to living every day thinking that, with no chance to voice, your side of the story, no chance to correct inconsistencies, and financially, just the whole mindset of walking around with it over your head every day, trying to do something, and you know that you're supposed to be in trial, you're supposed to be doing something, but it's never happening. You feel like that it's like it's deliberate, that so they're trying to keep you in here. So walking with that type of mindset, paying lawyers or paid a lawyer, and nothing happened.
What lawyer did you pay? You weren't paying Mr. Greenberg.
No, it was Elizabeth Rogan, and it took us like 2 years. We collected up $7,000-8,000 for her to get on this case, to get the ball rolling on this case, and she took the money and said that she's closing her office. We filed a grievance on that, and they said that the money went towards was it retainer fee? Oh, some excuse that they used to say that she did her job by looking at your case, so she didn't have to complete. So I was back at square one. So we kept writing letters in. But yeah, personally, like everybody's dead. Everybody I don't remember, even areas that we don't remember. Like myself personally, my counsel, I can't speak for him because he's passed, but it affected me in a lot of ways. Even things that buried by trauma, buried by situations that's happening now in prison, now in my real life right now. It just takes the back seat, so it affects me in a lot of ways. It's really mirrored. You really can't even just pinpoint one or two.
Who is dead who you think would be helpful to your case if we were going through your case again?
Who would be helpful to my case? First and foremost, rest in peace, Carl Greenberg. Secondly, David Mirez. Third, Casimir Ybarra.
Say that name again?
Casimir Ybarra, aka Mingo.
Mingo.
Yes, sir. A lot of my friends, like the only guys that's alive is me and my co-defendant that's in prison. We're the only two left alive in that whole area from that, you know, how you say generation, I don't know what you would call it, but we're the only ones that's still alive and we're the ones in prison. So, yeah, I believe that they most definitely, because the inconsistencies, the time when statements and the time when trial and the pressure and the coercion and a lot of things that took place in that time underneath the nature of the crime and the, God bless the deceased, you know, all that going on, it affected the trial, especially for kids who couldn't express themselves and couldn't really just, you know, fear led us on every level, but they could have brought clarity as adults or clarity after the smoke settled to the situation in a lot of ways that I feel and I believe and I know was inconsistent and was incorrect during the trial.
Now, you said Carl Greenberg, may he rest in peace. Did you mean Mr. Gashard, the trial lawyer?
Excuse me, I meant Gashard. I apologize. My bad.
I'm sorry, I didn't mean to cut you off. Was there anything else you wanted to say so far as how the delay affected you personally? And we'll talk more about it later on when we talk about oppressive incarceration. But is there anything more you wanted to say at this point?
That's pretty much it. You know, just the prejudice of the time, the mindset, the financial. That's it.
Okay.
Mr. Singleton, it was your family that tracked down Ms. Rogan to potentially be an appellate lawyer for you?
They concluded Ms. Rogan, but I met her through a guy that there was a case going on in my in the prison that I was in, and this person had Elizabeth Rogan as a lawyer. Okay. So he kind of recommended me, and I told my people to contact her. He contacted her. She asked for you know, an overview of what was going on. When I wrote what was going on, she didn't believe me. She said she would need to see the transcript. I guess she got the transcript from one of my family members, I don't remember. And when she got the transcripts, she was like, you know, I'm gonna take this case.
Okay.
Now, did you know, or did you ever find out whether there was any connection between her and Gashard or Greenberg?
I do know it's a connection between her and Greenberg because that's when things went. And, you know, again, it could be the...
Your Honor?
Stop for a second.
I would ask that he lay a foundation for personal knowledge of a connection between Ms. Rogan and Mr.
Sure. We're
Greenberg.
Way out in speculative land.
I thought that's what he was doing.
I thought he was about to say this is, well, go ahead. Why don't you lay the foundation before Mr. Singleton, who's never met Ms. Rogan in person, I suspect.
Yeah, I met her, you know, when she came to visit me. She came to the prison. When she visited the other guy, she would have a conversation with me after she received my letters and whatnot.
Okay.
But she said, you know, she knew Greenberg personally and said that he used to, you know, hold seminars or whatever the case may be. And I told her that was the person that was assigned to my case. But, you know, I told her he never did anything. And, you know, she looked at it like, oh, wow. But after that time, it's like when I told her that Greenberg was my lawyer, that was the last time I spoke with her outside of letters.
Okay.
So that kind of ended what, if anything, she was doing for you?
I assume, but I'm not, you know, I'm not sure, but that was the last time that I spoke with her face to face. Everything was letters until it was at a point where I'm closing my office, you know, here's the address to another lawyer that can help you. Peace. Took the money.
Let's talk then to the second part of that question. Anything you wanted to add so far as how the delay affected your ability to present your amended motion for new trial? Anything else you want to add to that?
I would say just the same thing. I believe that it affected me in the ability where I could bring there's no ability to review logins, old institutions, memories diminish. Excuse me, people's died. Documents and institution is gone. You can't retrieve them in no type of way. I believe that alone, time doing what time does, allowed a big unknown variable to take place in my case. And just for the fact that, the things that the state hold, oh, he was in the car, nothing else matters. It's like, of course that affects my case. It's nothing to combat that if we only going on a simplified view that, you got in the car, oh, you gave him a gun, you're guilty, no complexities to this case. It's just, you're done. So yeah, of course, if these things could speak up in any type of way, I think they would be beneficial to my case. And because they cannot, then I feel like it affects me in a negative manner.
Let's talk then a little bit more about prejudice. What, if anything, can you tell the court about oppressive incarceration?
Okay, we're expected to, like this hearing is about me establishing a prejudice and saying that, why did you, what attempts did you make to have a motion for new trial? When you're in prison, and I'm sure you all know secondhand because you're judges and DAs and lawyers, but when you're in prison, it's kind of hard to concentrate on, exclusively push if you don't have no money, exclusively push if you in a situation, you got oppression from gang members, you got oppression from these people, you got to deal with this, you got to deal with that. It's a lot of things that go on besides just diligently pushing for a case like every single day of the week, like I was hearing. It's not going to be exactly like that because there's so many other things that press you in prison, especially in today's prison. So it's like, of course, in a situation with guards, especially at the beginning of my time, police made it extremely hard to do anything because of who was involved in my case, period.
So your oppressive incarceration then started right from the beginning?
They sent me to Lee Arendelle State Prison, where it wasn't about just doing time. We getting raped, we getting snatched up. It's all type of weird stuff going on in Lee Arendelle. Why they shut it down? You feel me? It's obvious. This is not even and excuse me, but these are the obvious facts. You send me to Lee Arendelle State Prison at 17. It's a lot more to worry about than writing a letter. It's a lot more than worry about than just, than things of this nature. It's like you're trying to survive. You're trying not to be a girl in prison, on a daily basis. And there's no break from that. So when you do find time to write a letter or contact a lawyer, you're back to the reality of what you're facing. This is a reality. And then when you get to the point where everybody's ignoring you, you feel like you're stuck in this place. So yeah, oppressive is an understatement.
You've mentioned a little bit, but anything else you want to add so far as anxiety and concern, that factor so far as prejudice?
And yeah, I thought I was speaking already about the mindset. We walk with this every day. If you're unheard, if people say that, ignoring your letters and say that, oh, we can't do this because there's a lawyer on your file. If I try to file a motion and they tell me that, contact your lawyer on file, blase, blase. If for example, anxiety, I didn't even know I had anxiety till I tried to go back to Fulton County. Things to this nature, when I first came to Fulton County, we jumped on twice by the officers in my metro facility, we jumped on by the Clayton County officers when I went to Clayton County when they called me to the shower room. So you speak about, you got to live with this and you don't think it affects you until you're in a situation where it does and you notice it. So all this affects how fast we write a letter or how fast we try to get back into court so that we can have, a new trial 20-something years later.
You talked a little bit about dimming memories and loss of exculpatory evidence. Anything you wanted to add to that?
Exculpatory evidence, well, during the prison, during my bid, a lot of evidence has been lost. The last situation was we had, there was a guy from Fulton County, I think he was a municipal DA. He said, a lot of time people lie, but he was just so knowledgeable that.
Objection. It sounds like he's testifying to what some unnamed person said. I
can give you his name, Kia Tabatobi, but at the same time.
The name actually doesn't matter. It's still hearsay. So why don't you tell me what you want to tell me about your situation, but don't relay what someone else told you unless Mr. court specifically asks you, well, what did so-and-so say? And then that'll give Mr. Armstrong a chance to think through whether he's going to object to that or not.
And it's
Okay,
true,
what-
Mr. Singleton, first, we've tried to find this person, right? And that's another person we cannot find to bring in as a witness.
True.
And this person is a former prosecutor who has what connection to whom?
What's your understanding of?
His name was he was supposed to be part of the municipal court. He had got caught with drugs and he was banned or barred or whatever the case may be.
But he was with the Fulton County Prosecutor's Office.
The municipal, like the city court, the not the criminal side, but the lower courts. I
Okay.
don't know, but that's just my memory. We talking about 20-some years ago.
And you met him, you were in jail with this guy?
I was in prison. He was an Iranian descent out of Lee Arundel State Prison. You can look him up, Kia Tabatovi. And from there, but I'm just speaking about where the documents came and how they left. He showed me how to get the documents in. I got the indictments. I got the all type, and he was the one who introduced me to the a technique that he said was used in Fulton County, which was being done in my place, where special presentments, the method is a special presentment, but the face of it is a grand jury indictment. And he, you know, I had all the paperwork on that. Long story short, throughout the passages of time, there was a riot in Waycross. Everything was destroyed, flooded, and, you know, thrown away by the administration after the riot calmed down. But this, as well as an autopsy from the deceased, and it showed something that.
Objection, he's now referring to what an autopsy showed.
Right. I mean, if it's the autopsy in this case, that's in the record. So we've got that.
But he's talking about missing records. So I'd like to be able to have him finish his sentence.
So why don't you ask a specific question, because we're roaming here.
Your Honor, my objection is still hearsay. He's testifying about.
Okay, let's hear what the question is, and then I'll reevaluate.
Okay, was there a missing diagram that we tried to find?
Yes, the diagram that I explained to you, it was originally, it was in the discovery package upon, you know, when I first received it 2 decades ago. But I guess when, after we lost it during the riot, when Mr. David came on the case and I asked him to go into it, you know, we looking for it, looking through all the files, he can't find it as well. And this was very important because.
But it was a diagram that was available at trial. Right now, we can't find it, but it sounds like if you had it with you in jail after your conviction, then it's something that the state produced to Mr. Guichard. If the state wanted to use it, they could have used it. If Mr. Guichard wanted to use it, he could have used it. You didn't have the only copy of it.
I can't say that, but I would guess.
I'm telling you, you did not have the only copy of it. So
that's our point, is that Mr. Guichard did not use it. So
yes, I mean, whatever it is.
Why was this diagram important?
The diagram was important because some of the language that was used by the prosecutors in trial was how he was shot and where I was during the shooting. And according to the prosecutors, he was shot in the chest. In trial, he was shot in the chest by Mike sitting in the car with me, shot him, we ran off together. When you look at the diagram, it showed that the bullet entered in the upper right shoulder, from the right to left in a downward angle, from the top of his shoulder to a downward angle from outside the right area. And with that would be completely inconsistent with that. These are the inconsistencies that made it seem like I was there with him when he shot the man, he grabbed me, we ran off together. And I still say that did not happen. And the diagram would actually show everything that was said even before a trial or a case was started, that, you know, how he was shot, where I was when he shot him. The shells that showed in the diagram show that shells were at the back of the car. How was you running with me, but still shooting 10 rounds at the back of a car when I'm going the whole opposite way? How did I not know a man was shot right in front of me? Shot him in the car with me, which is the reason why I went to trial.
Anyway, long story short, that's one of our complaints, that Gashard didn't use that in your defense, and also that he could have used Mr. Dixon to say, in essence, what you just said, not as an expert, but just this is what it shows.
It's impossible to shoot a man sitting down on the top of his shoulders.
Now, you mentioned briefly, but we've also tried to get records that are missing to show the show up that Detective Martin did with Officer Poplis, with you in the juvenile facility, meetings between the state's attorney and Waters. But again, because of the passage of time, whatever, those records are no longer available. Is that correct?
That is correct.
Now, let's talk about you. How old are you now?
41.
And how old were you when this happened back in 2000?
I just turned 16.
Okay. Tell us about you when you had just turned 16 when this happened. Enlighten the court, tell us not only what it was like, but tell us about you, your environment, whatever.
Objection, Your Honor, relevance.
What's the relevance of how Mr. Singleton was when he just turned 16?
One, it explains some of the evidence that came out at the trial that was not pursued by Mr. Gashard. Two, it shows or corroborates the need to have a juvenile expert witness. And three,
It doesn't have to be 3. I just was curious.
my wife always says 3.
Yeah, that's not who you are.
I mean, that's not who you are.
No.
3, I think it would be important because we all have this tendency. I look at him every day, and I think this is Leslie Singleton. I can't imagine Leslie Singleton just turned 16. So I think that's why it's important for us to know who and what Leslie Singleton was when he just turned 16.
Okay. What's an example of one that there's evidence that Mr. Gashard didn't use? Mr. Singleton was the age he was. He must have looked like a very, very young man in trial. And I'm sure it came up at some point that he was not 41 at trial.
Yeah, he didn't file the competency. He didn't pursue it at sentencing, didn't call a expert witness, and didn't elicit this type of evidence at trial, all of which could have invited a lesser offense.
Got it. So we don't need Mr. Singleton to tell us that. That's not in the record. He did none of those things. So you're able to argue, here's another example of things that weren't done that could have, should have been done. Someone who was doing a competent job on Mr. Singleton's behalf should have or could have done those things. So I don't need Mr. Singleton to talk about those.
But you do not have in front of you evidence, so far as an example, guns. Why did Leslie Singleton have a gun? Why did Michael Waters have a gun?
Okay, but you can ask about those things and we'll see if that elicits an objection. I just didn't understand. Your number one was, hey, I need Mr. Singleton to talk about all this evidence that was there. And either the evidence was admitted and then that led to a verdict, or it wasn't used, but then you would be arguing, gosh, Gashard, if he were being proficient, would have used it. Mr. Singleton's opinion about whether Mr. Gashard should have used it or not isn't relevant.
I agree.
Okay.
And I do believe it is irrelevant what the facts actually were for this court.
Okay. So you can pursue this. Let's ask a different question.
With that, going back to you, just turned 16, Fulton County, Clayton County. What about kids? I mean, kids, your age group, whether it's you, Waters, Yabera, Mraz.
I would say at that time, easily influenced, easily impressionable, like music, whatever was the trendy way, whatever was the look. The environment was a violent environment, of course. We had different things. So there was a look that you wanted to carry out. There was a certain type of, I don't want to say ego, but it's just how kids was. We was ghetto kids. We was kids from the bottom. We was kids from, no supervision, no parents. So we do whatever we kind of, it was that type of vibe. So, that's how we were at that age. We were young, impressionable, impulsive. We wasn't stupid, but we wasn't, you know, as smart as you would expect to be in a courtroom. You know, we wasn't like that, and we just made bad choices. You know, all the time. We just was kids, the average kid from the hood, not the average kid from Sandy Springs, not the average kid from Roswell and other great places where things like this never take place. But honestly, these are the options that we deal with on a daily basis: ignorance, indigence, you know, making bad choices off deprivation. There's a lot of different things that we do that the rest of the kids in these other areas never even have to think about doing, or never even have to think about not doing, rather. And you know, that's the honest truth, and it's not an excuse, but it's the reality that we were set in. You know, and that's why so many of us in prison. Not because everybody is just evil, malicious, murderers, but these are the options that we make bad choices.
What about Michael Waters carrying a gun or kids carrying guns?
Today, kids carry guns.
I mean, back when you had just turned 16.
Back then, guns was around. We you know, all kids had guns, but not as much as today. But all kids had guns. If you was, you know, your hood and their hood, and you know, little street skating ring beefs and things of that nature. So yeah, guns, even paint guns, anything that resembled a gun. You know, people would always have them just for that look.
Well, in Clayton County, you had some type of broken pellet gun or something like that. Is that correct?
Yeah, we had that was something big in our area. We did paintball fights and, you know, pellet gun fights. And the more realer the pellet gun was, the more realer the BB gun was, the more we wanted it.
Okay. Well, carrying guns, did that mean somebody was going to get robbed or murdered or killed?
No, just because somebody carried a gun, same as today, black or white. Just because somebody carries a gun doesn't mean they have a malicious intent to go kill somebody or rob somebody. You know, unfortunately, stupid things do happen, but no, that doesn't mean that every time we put on a weapon, sometimes it's so you won't get jumped, so you can look like you got protection. Sometimes it's like that as well. It's not about you going after you being a predator every time you grab a weapon or grab something that resembles a weapon. Sometimes you do it to protect yourself from other people, being jumped on, you know, being shot at, or whatever the case may be.
So when all this happened, it was not unusual for Mike Waters to have a gun.
Mike had all the guns, you know, like the real guns, but it wasn't nothing that was like wow, you know what I mean? It wasn't nothing like that. He liked the guns more so than, you know, the rest of us, but he was a little more experienced than the rest of us. You know, he'd been to jail. He's been in those situations. We ain't quite got to that level he was on yet.
I sent you defendant's proposed exhibits B and C, the post-conviction letter and affidavit from Mike Waters. After your Fulton County conviction, and I guess in Clayton County before he testified, did you have a chance to talk to him?
One more time. After the conviction?
And after Fulton County, but before the Clayton County trial, did you talk to Mike Waters?
We had one, Clayton County, he was in the holding cell, I was in the holding cell about this close from each other. So we like talked through the glass.
And did he say anything about his testimony?
Objection, hearsay.
Right, let's not get into what Mr. Waters said.
Admission against interest, Your Honor.
What? I'm sorry.
He's going to told him that he lied and why. At that time, he had not yet been sentenced. So that is certainly an admission that could undo the sentence agreement that he had.
I need to understand the time frame a little bit better. So I understand the geography. For some reason, Mr. Waters is down in Clayton County Jail. Mr. Singleton is. Mr. Singleton is down there. What's happened here already?
Okay. So is this on the first day of trial, before the trial? When did this discussion or conversation take place?
Mike was, when Mike came down, and I don't think it was a day or two, a day trial and 1 day sentencing. I'm not sure, but The day that he was in the holding cell and I was across from the holding cell during my trial period in Clayton County for the armed robbery case.
But is the Clayton trial before or after the Fulton?
After.
So Mr. Waters has already pled guilty and been sentenced for the murder?
Not been sentenced, pled guilty.
Pled guilty, not yet sentenced, and he is in Clayton to testify against?
As part of his agreement to get the sentence that he worked out so far as a plea agreement.
Okay, so he's traveling under, I've pled and I've committed to the state to provide truthful information. I haven't been sentenced yet.
Right.
Hold on one sec. He encounters Mr. Singleton and they allegedly have a conversation.
Both in the holding cells, looking at his demonstration, 2-3.
Got that. And you think that what Mr. Waters said isn't hearsay because it's a
Mission against interest.
Okay.
Because he has an ongoing plea agreement.
Okay. And so if what he said was, I lied in my testimony, that's not actually consistent with his commitment to the state. And so why would he tell someone something like that? Because that's just going to get potentially Mr. Waters in some trouble.
Yeah, part of his agreement was that he would provide truthful testimony.
Okay.
He says that.
You've given me a better setting. Mr. Armstrong, tell me your concerns about this.
I have many concerns about it. I don't believe that'd be lawful under any circumstances, but I'm going to try and confirm when it was that Waters pled guilty and was sentenced.
Well, but let's assume that I don't know that it matters. If he has committed to testify truthfully, then if he's not, one, it's perjury. He's saying I committed a crime. And two, he's potentially opening himself up to the state changing things in his situation, whether he's been sentenced yet or not, if it comes to light that he didn't testify truthfully.
Two things about that. I don't think that that is accurate.
Which part?
The idea that after he's been sentenced, that his sentence would change. Unless you're a first offender, your sentence doesn't change after you've been sentenced.
Which is probably why he wasn't sentenced yet. If I were the prosecutor, I wouldn't sentence him before he testified.
The Clayton County case was months after the Fulton County case. I have to check. They presented no dates whatsoever. I'm going to try and check the dates.
Got it. Okay.
Preliminarily, the sentence notes on Odyssey for Michael Waters are in April of 2001, and this case wasn't until the summer of 2001. So number one, it's factually incorrect. But number two, basically creating hearsay to impeach the testimony of a testimony witness is not something that comes into the motion for new trial. That's something that basically the law does not allow for somebody to simply to have some witness impeach their own testimony at trial. That wouldn't be the basis for an extraordinary motion for new trial. And it's not a basis for a self-interested defendant to get in hearsay where, oh, everybody who made testimony against me has admitted to me that I am a saint and nothing ever happened.
Right.
They all lied on me. That's nothing I've ever seen happen, and all law that I'm aware of is opposed to that.
But why is it not a statement against interest to say I lied while testifying? That's perjury. I'm admitting a crime. And so there's your indicia of reliability. Why would you make that up if it didn't happen? Is that not a hearsay exception? Is that sort of like res gestae? People like to say it. Oh, statement against interest, so it comes in.
So statement against interest, if it basically, the way that it works is if I'm making a statement and it is so far inculpates me and shows that basically it comes in against two different people. So if I was the person who's making the declarant, that my statement to somebody else would be admissible against this other person if basically that's the way the statement came in. It doesn't really ever work any other circumstance. Because if it is this person is the declarant, it comes in as a statement of party opponent. So how it comes in is when this person is unavailable. I will agree that Mike Waters is unavailable.
Yeah.
Basically, we could get it in the sense of saying like this person made a statement that's so far against his interest that it's reliable to use it against this individual when he's talking to somebody else. The one also issue with the indicia of reliability is the idea that the person who has just testified against a defendant and got him in prison for life all of a sudden just gives him more information, says like, I totally lied for all that, that's not something that we consider reliable. Like that's not a relationship where I talk to my brother constantly every day and I tell him I can confide in things. That's not anything close to what I've ever seen it used for.
Okay. Mr. Hort?
One, I'm sorry, but I don't have the access to the Clayton County dates, so I'm not sure if I agree or disagree with Mr. Armstrong. My understanding was that Clayton County was after Fulton County. That
Well, you are in agreement. Mr. Armstrong said, here are the sentencing notes for Mr. Waters, because this is so old we can't pull them up, but they were a January 2000X, and the Clayton trial, he believed, was many months later in 2000X. So that data should...
The trial was in July 2001, July 11th and 12th. Those are the two volumes of the transcripts that we've previously admitted into the record.
Yeah. He said July.
I said the summer is what I said.
Okay.
And Mike Waters, his sentencing notes are listed as being in April of 2001.
Okay. So sentencing before Clayton trial.
if the recitation is correct.
Okay.
Now, looking at the court rule, as the court has kind of somewhat already said, it doesn't matter. 24-8-803, so far as declarant unavailable. A statement against interest is a statement which a reasonable person in the declarant's position would have made only if the person believed it to be true, because when made, it was so contrary to the declarant's proprietary or pecuniary interest, or had so great a tendency to invalidate a claim by the declarant against another, or to expose the declarant to civil or criminal liability. That's again with a court reference to perjury. And then B, supported by corroborating circumstances that clearly indicate the trustworthiness of the statement if it's offered in a criminal case as a statement that tends to expose the declarant to criminal liability. And the corroborating circumstances there are his refusal to testify in Clayton County, and then also—
Ended up not testifying in Clayton County.
That, oh, I wish we had you as the judge in that case. The judge in front of the jury demanded he testify. He refused to testify, held him in contempt in front of the jury, demanded he testify.
In front of the jury?
Yes.
Okay.
And did it again and again and again. He did not testify, and instead took all that contempt by the judge.
So, Mr. Singleton, I need you to unmute. I'm going to ask you a question, and then we may just move on from this part. And we also may take a break in a little bit. Mr. Waters was talking to you about his testimony at your trial?
In the holding cell during my trial when he was supposed to come on the stand. We was in the holding cell. We were both—
Okay, I didn't ask the question well, because you had two trials, of course. You were in Clayton, he was in Clayton. He was going to testify at your Clayton trial. I just learned he didn't. I'm sure I had been told that before. I just didn't remember. He did not. He refused to testify. But you were, before we had this long legal discussion about Rule 803, you were about to say, hey, Michael told me he lied about. And so I don't want you to go into the specifics of what Mr. Waters told you, but was he talking about his testimony in your murder trial, or was he talking about things he told law enforcement about your Clayton County robbery trial?
I think—
and if you don't know, then that's the answer.
I do know, but I would say it all ties in together. But yes, it was what he told them in Fulton County in the trial, in the just everything whatever he told them, that he said he was gonna make it right. He said why, and he said he was gonna make it right. And that's when he went out and he did what he did.
I'm not sure when you say he did what he did, meaning he went out into the Clayton courtroom and said, I'm not going to testify.
Just was belligerent, just, showing out. He just was doing this, he was in his mode like, hey, I don't feel right testifying. I ain't doing this. I'm not doing this. I don't feel right doing this. I can't do this. And, he just kept repeating, I'm not testifying. I'm not getting on court.
That was the way in his mind he was making it right.
Yeah, but at the same time, yes, I guess. But making it right for me was to hopefully write the lawyers, write somebody, and let them know, whatever the case may be. But we didn't have that type of time to do all that, and I really didn't I really, honestly, in my mind, I'm still young. I couldn't say, hey, I need you to write a motion to say this and this and that. But
what steps have you taken, if any, and you don't have to have taken any, but what steps have you taken, if any, to connect with Mr. Waters over the last, let's say, 10 years, when you guys were both much older, more mature, not wrapped up in that kind of, I'm a young thug kind of guy?
Well, I know one time I was in Augusta and he was in Augusta. I was in Augusta for medical reasons and he actually stayed there. That was one time that I seen him. And the next time was during a parole campaign, where I was trying to come up for parole and I'm getting all the recommendations, community, et cetera, et cetera. We all from the same community, his family, et cetera, his girlfriend, his child, et cetera. And he said that he would write a statement, and he did write a statement. And I don't know if this was my first, I think this was my second time coming up for parole. So I'm not pretty sure how many years that was, but it was the second time I came up for parole where our families kind of, connected with each other for that reason, or whoever was mediator.
Okay.
And I'm not sure you understood the judge's question. When you talked to him in Clayton County in the holding cells, and I'm not putting words in your mouth, so correct me if I'm wrong, did he tell you that he lied at the Fulton County trial, and then why?
Objection, hearsay.
Well, I think that's part of the questions that the court had, and I want to make sure that there's no misunderstanding that the conversation they had in Clayton County was that he had lied at the Fulton County trial, and then was also told Leslie why he did lie. That kind of gets into what Leslie was just trying to tell you. Okay.
Why don't we take a break now? I'm going to come back out in about 10 minutes. I'm going to look at 803, but I want to just tee up what I think the issue is. It sounds like Mr. Singleton may say, Waters told me he lied at my trial, which would be Waters saying, I perjured myself, which would be Waters saying, I committed a crime, which would be a statement against interest. So I'm going to try to figure out why that wouldn't come in under 803.
I can tell you why it doesn't come out under 803.
Pick your number.
It's 804.
Okay, 804.
There's no indicia of reliability. That's separate from the statement itself, and that's something that has to be shown. This is a self-interested person talking about this statement for the first time decades later, where his own testimony at trial.
Meaning Mr. Singleton's indicia of reliability, not Waters's.
No, the indicia of reliability of how we know this statement was made. Otherwise, we just bring in hearsay for everything.
Not for everything, because if he was going to say, Mike Waters missed me and he gave me a hug and we talked about his dog, those aren't statements against interest. Mike Waters saying my dog was a great dog, it was one of the best dogs in the world, that's not coming in.
But every criminal defendant going forward would say, I actually had a conversation with everybody and they told me, they admitted they lied.
I understand that, but it's specifically me as criminal defendant saying, oh yeah, I talked to that guy and he told me he lied. Not he told me about his dog.
So it is Rule 804.
Okay.
And also I just wanted to point out that Mike Waters pled guilty on April 16th, 2001. And so that was 3 months before the Clayton County trial. And if you'd like to see the signature date for George Downs, it's on my screen right now.
No, but it's when was he sentenced?
That's a final sentencing sheet.
Oh, okay. He may have pled guilty.
He pled guilty earlier, but the sentence
was sentenced in April of 01.
16th, 2001.
Okay. So he was not awaiting sentencing when he would have had this purported conversation with Mr. Singleton.
Correct.
Okay. I don't want us to get hung up. I mean, this is the whole Waters thing is going to remain murky because that affidavit's going to remain on your desk and not mine. But I will. I need a break anyway, and Ms. Rivers does. So I'll come back out in a little bit. Something you.
I can wait.
Well, if it's something about 804, I don't want to come back and say, oh, well, you should also think about this. I'm going to go do my thinking.
Okay. Two things. And I agree with the court that perjury is probably the decisive question. But I also think reason, common sense, and Mr. Armstrong probably can verify this, that if a defendant post-sentencing violates a sentence agreement, it would not be beyond the realm of impossibility to do something about it.
Well, and he would have violated it pre-sentence because what he is saying is, I lied during your Fulton trial. And that was before all this. We're talking Clayton. He didn't testify in the Clayton trial. So he didn't say, I lied in your Clayton trial. He didn't testify. He's saying, I lied back before they sentenced me. And
when he said that in Clayton County, that was an admission against interest.
I get all that, but I'm all the more reason why I would, as the sentencing judge, feel quite empowered to modify that sentence if there, or be receptive to a motion from the state saying, wait a minute, we did it. That's not what happened in this case. But
No three, just two.
okay.
The corroborated circumstances, again, is Clayton County then, where he then refuses to testify, notwithstanding being placed in contempt over and over again. So I think that corroborates, one, why he doesn't want to testify, and two, because he's not going to testify falsely again.
Okay. All right. If you need a break, Mr. Singleton, you got about 10 minutes. What did you want to add?
Excuse me, can I ask a question to you, sir?
Which person?
Judge McBurney.
Yes.
Is there any way that we can get a copy of Mike's plea agreement?
Mike's plea agreement?
The transcript that described it out loud. And
yeah, I don't think there's a plea agreement. It's not like federal cases where there's a 9-page document that lists stuff. It would be whatever, unless you know there was a plea agreement.
I don't know that there's a written plea agreement, but I do know that Miss Ross sent the other parties, at least I have one for Luana Walsh, notice of Giglio, basically saying this is the deal that person has.
Right, and the deal would have been in the transcript of the plea colloquy, laying out all the things to which Mr. Waters has committed.
Correct.
Okay.
And that transcript
exists.
I believe I've read it. So I hope it's there. I hope I'm not making up memories.
All right. So the answer is hopefully Mr. Hort has Mr. Waters' plea transcript, and that's going to be the terms of whatever plea agreement there was between the state and Mr. Waters and his lawyer. Okay?
Thank you, sir. Can I use restroom?
Can. Go for it. We will not start till you're back. Oh, he turned the camera off.
Your Honor, are you doing your thinking on that?
Do I need to leave? Do I need to leave now?
No, you don't. It was fine. I didn't know you could turn the camera off. That was impressive. You don't need to leave it on. Turn it back on when you're back.
I learned how to use the laptop.
All right. Good job, Skills. No, I'm going to go back there.
Okay. I was making sure I can leave the courtroom.
You can leave the courtroom. I just had to see what this was. All right.
Oops, I went the wrong way.
Yeah. Yeah. That's what's that in roll one? Yeah, I think I'm wrong.
Excuse me. It's back. All right. So if you would unmute Mr. Singleton. Ms. Rivers, you ready to get back on the record?
Yes, I'm ready.
Great. We're back on the record in State versus Singleton, and I took a little look at 804B3A and B, and I do find that what Mr. Singleton has indicated he's about to talk about would be a statement against interest of Mr. Waters, in particular because it would expose him to criminal liability, i.e. perjury. And while the circumstances of trustworthiness aren't the most robust, I am comfortable that in this setting, a non-jury setting, that I will be able to give the statement the weight it is due. As I think about all the circumstances, to include the fact that soon after he said that, he, Mr. Waters, went into court and in fact didn't repeat what he did in the Fulton County Court. So if you want to continue to explore that, Mr. Hort, you can.
May I have a continuing objection to?
Yes.
Thank you, Judge.
Yep. On this topic, what did Waters say in the Clayton County Jail? Yes.
Thank you.
You're welcome.
Okay, Mr. Singleton, let's go back then to the holding cells, Clayton County, prior to your trial. What did Mr. Waters tell you?
When I asked him, we having that one-on-one opportunity to finally see each other after all this, and he was like, man, I know, man. He said, I know, but he was angry. He said he wasn't scared. He said he was angry. When I asked him, why did he do it? He said he was angry and they tricked him. And he said, he's talking about the DA, but he said that they told him that I was going to testify against him, or that I was putting him up under the bus. So he wanted to do it to me first. And that was exactly what he said. But he said, given the opportunity, not in those words per se, that he was going to make it right. And he was going to, clear up the record, I guess. And the first thing he did was he went into Clayton County and he did that. And later on, years later, he wrote the statement.
So we're talking about what he and you discussed there in the Clayton County Jail. That's it.
All right, yeah, that was it. Well, he was just basically saying that they made him do it. He was afraid. I mean, he wasn't afraid. He was angry. They tricked him, and he would make it right. Those are his words. And paraphrasing without being too literal for every single word that he said, that was the ultimate message that he gave me.
So then, I'm an older white person, you're a black kid. Is he then in essence admitting that he lied at the trial?
Objection leading.
You'd be able to argue the import or impact of what was said. The words are the words.
That's fine.
I don't think they're susceptible to a whole bunch of meanings. Oh, I follow it.
Thank you. All right. And Mr. Singleton, again, then just for the record, years later, when you were going through the parole process, that is when you ended up receiving that letter from him.
Yeah, it was my family actually, but it was a, it was a part of I was getting different recommendations, different letters from everywhere, and that was where that letter came from.
When we say that letter, we mean Defendant's Proposed Exhibit B.
I guess, but it was the letter, the letter for him to clear the record, so to speak, to say what happened.
Don't go into the contents of the letter, but you've referenced that he wrote a letter that in theory would be helpful for you as pardons and paroles was considering your case.
Thank you.
Okay.
I will move on. Now, going back again to you as a just turned 16-year-old juvenile, and I understand your reluctance to cause any pain to your mother, but what can you tell the court?
Objection vague. What is,
Let's ask the question differently,
Okay.
please.
What can you tell the court about you at that time frame so far as your family and living circumstances?
It really wasn't, at that particular time, my mom wasn't there. She just got locked up for whatever she got locked up for. And you already know my dad wasn't there, of course. And my older sister wasn't there. So it was just me, looking over my two younger ones. But it really wasn't a family setting like that. It was just a bunch of people trying to make it some type of way. It really wasn't family matters, or wasn't a family really. It just was people living on the same roof trying to make it until my mom got locked up, and then it just everything went down. Excuse my language.
And again, we've talked about this out of court. You don't want to cause any pain to your mom. For what, was she verbally and physically abusive to you, as you've indicated in your amended motion for new trial?
objection
Of course.
not relevant.
Stop.
Whether his mother was abusive to him on times other than the times of the crime is irrelevant. There's no relevance to it.
I would respect,
Wrong lawyer.
well, she might be better than me.
Well, it's okay.
I would respectfully cite House Bill 582.
Is that a code section?
I don't know what House Bill 582 is.
I will gladly read that.
Oh, is this the new law where victims of domestic violence, family violence
Child
can?
abuse.
Okay, got it. Of course, this isn't a case where Sergeant Griggs was the abuser. This is not Mr. Singleton shooting his mother.
And that's not required in the statute.
Can I ask what statute it is?
Yes, let me find it. It's in that 52-page amendment. Okay, if I have cited it correctly from Westlaw, it's House Bill 582, 2025 Georgia Laws Acts 131.
Right, but there's, I don't know if it's an entirely new statute that it enacted or if it amended one, but there's a statutory provision now about sentencing and how a defendant is entitled to admit certain evidence at sentencing, not during trial, because this is a sentencing issue. Of course, we're not talking about sentencing right now, but I understand the angle you're taking. What's the statute that?
It says if a court finds by a preponderance.
What statute? Is it 15? There is a statute that was either created or amended by that bill. And so it should say in the legislation, creates the new 1711-191. What's the statute?
I'm sorry, this is what I got from Westlaw.
Okay. All right. I can't get you that answer right away. But it was effective 10 days ago.
Yep.
July 1 is when it went into effect.
If it's a sentencing law, it has nothing to do with this case because the sentencing laws apply at the time of the offense, not later.
Interestingly, this law, though, and I don't think it's germane to the motion for new trial setting, but I'll hear from Mr. Hort in a minute. The legislation actually allows people who were sentenced before it to petition to have, I'm going to use the wrong term, their case reopened so that their sentence can be reviewed in light of the trauma, abuse, et cetera. So it is a peculiar statute, and it has language in it that makes it, in effect, retroactive. It creates a right of action for someone sentenced before its enactment to have their sentence reviewed in light of, the classic example would be someone who kills his or her abuser. I'm remembering, I'm not disagreeing with Mr. Hort, I think it also is just trauma in general. And so we're having a more trauma-informed sentencing hearing that doesn't justify what happened, but might explain what happened. And courts aren't required to do anything other than listen to it. So you still have a troubled look on your face.
The issue is that 5540 now says that they can amend just the same as before, but he filed a 51-page document yesterday, and I asked what had changed, and he wasn't able to tell me what had changed. And now it seems like a sentence that came up 25 years later is what he's amending it to.
Okay, I don't think.
We have 10 days to respond to things that he raises.
And you're 100% correct. I don't think, Mr. Hort, you are right now saying we need to deal with the sentence is the sentence, is life. I mean, it's not like I can tweak that, but well, maybe I can. But
I can read it to you.
No, I don't want you to read it to me. But I do want you to tell me, are you now adding a ground to the Washington trial that we certainly shouldn't talk about right now because Mr. Armstrong wasn't put on notice, and it doesn't sound like it's in your 51-page opus, but it
could be. He filed it yesterday.
I know. And is that new? This thing on page 18, is it new?
No, it only just happened. So yes.
Okay, there's nothing wrong with it being new. I just want it, so you have incorporated now the new statute.
Yes and no.
Okay.
And I'm sorry, but it's very important that you understand the distinction that I'm making. One, as I have mentioned already with Mr. Singleton, I understand his wish not to cause pain to his mom, but the physical abuse by her was a contributing factor to what happened in this case. And that then allows this court, if that petition is filed, to change a life sentence to a much lesser sentence.
Right.
And yes, if I can convince him to do this, we will be filing that petition with the court.
Okay, but it hasn't been filed yet, so that's not what Mr. Armstrong is up against right now.
That's number two, though.
Okay.
Number two, we have made the cruel and unusual punishment argument, sentencing and post-sentencing. And part of what we're trying to say that, if family violence or child abuse justifies a reduction in a life sentence, shouldn't the same be true for the young person that is still undeveloped and in an impressionable stage of life? So we're using that one as a comparison, that if family violence allows the court to do this, shouldn't all the other things that have happened in this young man's life be something for this court to consider, one, as to whether it was cruel and unusual punishment?
What's the cruel and unusual punishment part, as opposed to there are mitigating circumstances that would support a lower sentence, which argument is not yet in front of us?
Well, why would they put that in there if that wasn't somewhat of an indication that a life sentence may be cruel and unusual punishment?
Why would they put what in
where? Why
where?
would Georgia have done this? But for the acknowledgement that a life sentence isn't always appropriate, that in essence it is cruel and unusual punishment.
The new statute has the phrase cruel and unusual in it?
No, but I'm by comparison saying, if family violence allows a judge to change a life sentence, shouldn't other similar type of factors that were a contributing factor to what happened here, shouldn't that also allow the court to consider the appropriateness of the sentence, i.e. whether it was cruel and unusual?
Seems like that's a legislative decision that they didn't make.
Which is why I love the courts.
Okay.
Because the courts are the final straw.
All right. Sometimes they are. What you want to explore with Mr. Singleton right now, because he's not at the point of let's do that petition, is what was going on in his life that is akin to family violence that would explain in part the lifestyle he was leading, the decisions he made, et cetera.
Yes.
And why does that not go to mitigation at sentencing? And maybe Mr. Gishard didn't do that. I think we heard a lot of that from Ms. Wardell.
Look, if Mr. Gishard would have elicited this information, one, it's something the jury then could consider.
The jury?
Yes.
How would the jury, how would that have come in at trial? That I'm going to make one of these up, that Mr. Singleton's older brother routinely beat him. How would that be relevant at the trial of the murder of Sergeant Grigley?
If that is a factor in why he did anything he did do. I mean, think about it. If his mom was verbally and physically abusive to him, and some of the things are wow, and he's trying to get bail money to get his mom out of jail, what does that mean so far as a just turned 16-year-old kid? Does that mean that maybe you hang around with some guy, some other kid that
But explanatory factors aren't justifying factors. To get in front of a fact finder of guilt, innocence, something like that would be almost like a competency trial, which this wasn't. This was a guilt innocence trial.
About so far as intent.
I don't know how that's relevant to intent. I mean, why he did what he did isn't material to, did he knowingly do it? And I'm not aware of any evidence that Mr. Singleton didn't understand what a gun does, didn't understand what Mr. Waters was like, didn't understand that you shouldn't get in someone else's car unless you're invited to do so. It wasn't that kind of trial.
That's part of what this addresses. And if he would have used Susan Wardell with her expertise in juvenile behavior, she then would have explained why he did what he did, what happened. And it would have afforded an instruction for a lesser offense, for manslaughter.
For the person who didn't do the shooting?
Right.
Wow, I don't think I've ever heard of that. What would the sudden fit of passion be for the person who didn't shoot? How does that, walk me through the legal reasoning behind that?
Okay.
Because I guess part of this is, and maybe you just are putting up alternative theories. One of your theories is he really was peripherally involved if he had anything to do with it at all, in which case his intent doesn't matter because he was merely present. But if you're engaging in this, it was, oh, he was involved, but there's justification for it. It was somehow, it was a fit of passion that got him to get in Sergeant Grigley's car and try to drive it away. Not shoot Sergeant Grigley, because no one's saying he shot anyone.
And as everyone here knows, you don't have to have just one theory.
No,
You
I
can also-
understand.
Okay.
But one undercuts the other a little bit.
Oh, I've had pretty good success doing that at trial.
Okay.
Okay. Voluntary manslaughter occurs when one causes the death of another under circumstances which would otherwise be murder, only if one acts solely as a result of a sudden, violent, and irresistible passion that was caused by a serious provocation sufficient to excite such passion in a reasonable person. And then I've got more cited in our amended motion for a new trial.
Is this part about voluntary manslaughter another new addition to the amended motion for new trial?
No.
That's been there for a while.
For a while.
Okay.
And again, twofold. One is the need to use Susan Wardell or an expert witness. And two, Gashard should have asked for voluntary manslaughter.
On what basis, though? What if you're going to be Gashard for a minute, articulate to me, I'll play Judge Downs for a minute, the sudden, violent, irresistible passion that overcame what that is that applies to Mr. Singleton, not Waters, who had a gun pulled on him, of course, after he was carjacking someone. And couple that with the fact that, of course, no one is alleging that Mr. Singleton actually committed the act that killed anyone. So this irresistible passion would have prompted him to actually not kill anyone.
No. First of all, that one, you need to take into factor who he was. And that's where we're trying to go here. Two, what caused him to go into that car? And they're all interrelated. Nobody waved a gun at Waters. Waters is the one that was waving the gun around. And then threw to Leslie that cell phone. Leslie grabbed it, threw it down, but then, oh wow, what have I done? I got to get in the car. And I'm not describing it as adequately as he can, but it all talks about this serious provocation sufficient to excite passion in a reasonable person. And we're talking about a 16-year-old when we talk about a reasonable person.
Okay. All right. So we've gone a little bit astray. You want to have Mr. Singleton talk about traumatic incidents in his life?
Well, he does not want to, so I just wanted to verify what we put in the amended motion for new trial, that it's correct, that his mom was verbally and physically abusive to him.
Okay, that's it.
That's as far as he wants me to go.
Okay.
And Your Honor, I would just like to state what my objection is. It's to relevance, and the code section that I'm looking at, well, I found the bill and there's different codes involved.
Yeah.
It appears that they are creating or expanding a defensive justification based on these things. And so reading in pari materia, it is justification against the person committing these types of things against you. And so I would suggest in this case, there's no relevance to it because under the new statute, it wouldn't apply to him because there's no allegation that his mother was doing anything that causes. Melvin Grigley wasn't causing child abuse to him. Officer Pappas wasn't causing child abuse to him. Nothing that was in this case involving that. So my relevance is, even under the new statute, it's not relevant because reading it together, it refers to that defensive justification.
So I agree with you on that part. And I pressed Mr. Hort on that because the victim in this case is not Mr. Singleton's mom, where that would play in. But at a later time, it sounds like we may discuss other parts of the other changes to the criminal code wrought by that bill, because you pointed a part of it, but there is part that has nothing to do with justification. It has to do with sentencing and what a court now must allow a defendant to present if he or she wants to do that. And it does create this ability to go below life in certain instances.
But my point is that the law allows that for people who were sentenced before the enactment date and for whom this information wasn't presented at their trial, so it wasn't something that was allowed for that justification defense. And so reading the two statutes together, my assertion is that it's only relevant to those cases.
Okay.
Otherwise, it's just, I molested a child because somebody hurt me before. That's not a defense.
Okay.
And that, I don't believe that's part of the purposes of the statute. And that's why I was saying in pari materia, I don't normally try to use Latin.
No, I understand. So really to use either prong, the justification prong or the sentencing prong, you have to look at them together, and they've all been linked in the statute to, there are things that not just explain behavior, but might to a certain extent justify it, so that that ought to be factored in sentencing.
Correct. So if you didn't present the justification defense because you either couldn't or because it just didn't happen,
Yep.
you'd be able to show mitigation.
Yep.
And I would
Okay.
respectfully disagree, and obviously the court can read the statute itself.
Right. I have. It
There
just
are
was
two
a while
separate-
ago, and it's a big change.
Yes, it is.
Okay. All right. Well, we don't need to wrestle with that today.
Okay. I did want to point also the involuntary manslaughter.
Involuntary.
Yes, and that's
Okay.
been there for a while also.
Excuse me,
Yes, ma'am.
I need the Latin phrase that Mr. Armstrong just used.
In pari materia, IN space PARI space MATERIA.
Thank you.
And he won't use any more Latin today.
I will try my best to avoid that.
Right. Another way to say you have to read these two things together. Together is a good non-Latin word. Okay.
And I would, again, for everyone who's listening, sometimes our humor is here, and it's certainly not a reflection of the court, Mr. Armstrong or myself's less than serious consideration in this case. So involuntary manslaughter talks about when a person causes the death of another human being without any intention to do so by the commission of simple battery or reckless conduct. So that's the reckless conduct falls into play here. And again, that to me would be more aptly proven by showing who the 16-year-old juvenile was.
Okay. Let's get back to questions for Mr. Singleton. It'd be great if we're able to wrap up his testimony today, but I don't know what you've got left.
I'm on page 2 of 20.
Okay, we won't finish it today.
Can I verify that what's in the amended motion for new trial is true, that his mother was verbally and physically abusive to him?
Sure.
Is that correct, Mr. Singleton?
Yes, sir.
Your Honor, my screen has gone back to the old screen.
Okay, I'll add it. I don't know why it dropped off. Keep going.
If I may ask, do we know how much time coffee is going to be able to give us today?
You'll have to ask.
Is the coffee person there?
Is they right outside the door? I don't want to yell on the mic. $5 o'clock.
Thank you. Okay, thank you, Your Honor. Mr. Singleton, let's turn to a somewhat different subject. What can you tell the court? Why was your sentence as a juvenile to life in prison cruel and unusual punishment?
Objection, Your Honor. His opinion is irrelevant.
I'm not asking for his opinion,
What would his answer be other than his opinion?
the facts.
Why don't you ask him questions that produce factual answers rather than opinion? That question is going to be his opinion as to how it was cruel and unusual. He can give you some facts that allow you to argue, look, the fact that X happened, that's cruel, that's unusual.
It's always hard to tell what way Mr. Armstrong is going to object.
I saw that one coming.
What facts can you tell us so far as your sentence as a juvenile to life in prison? Again, facts, not opinion. Why this being a cruel and unusual punishment?
That's kind of a harder question to answer. Facts. I don't see how it wouldn't be influenced by my opinion. But the facts that I did not shoot the man, I did not plan to shoot the man, but I'm sentenced to die in prison. I feel like it's cruel and unusual given or considering the person. And I can speak retrospectively as an adult now because I'm not the child anymore. When you think about the mindset now, 25 years later, in comparison to a child, if something was like that to happen now, I can understand it's a lot of, but as a child, I feel like I know factually because of my involvement, I don't think that I should be sentenced to die in prison.
Objection, this is opinion.
Okay, right. Now we're into opinion because you're saying, I think I shouldn't. I'm going to direct Mr. Hort to ask you different questions because he's putting you in a little bit of a bind where I appreciate your answer. You were really answering his question, but it turned into a question that wasn't proper. So I'm going to get the mic back to him and we'll see if he wants to try to tack differently.
Was there any way about you factually as a juvenile? Even if you were the one that shot the sergeant.
Factually, my mind, my control of my emotions, you're not there as a child, period. And I don't care what kind of child you are, you're not there fully to say that you're irreparable, that you don't deserve to have a second chance in life, that you shouldn't be on the street and no type of, that's not factually, a child is not there to receive a death sentence for a party to a crime. And that's not an opinion, that's a fact. A child's mind is not there under any circumstances. They're not fit. When I witness children today in prison, they're not fit.
Objection, Your Honor, argumentative.
All right, we're arguing now. Again, Mr. Hort, this area may be too problematic.
I will move to it. Did Gashard or Greenberg ever talk to you about any of this?
Never.
Now, what about post-sentencing? Again, was cruel and unusual punishment. What can you tell the court about physical, mental harm, traumatic experience? What can you tell the court?
Your Honor, I object to relevance.
Right. Let's say 4 years in, he got shanked. What does that have to do with whether he should get a new trial?
It's in line with what we have put into our amended motion for new trials.
You can put anything you want in your motion. It doesn't mean that that's what is relevant to should there be a new trial in this case.
But if there are facts in the motion, I assume the court will then consider facts.
You could put in a fact that President Obama got elected in whatever year he got elected. That's not relevant to whether Mr. Singleton should get a new trial and whether prison is a bad place. And I think a lot of people would agree with that. It's not relevant to was there a sufficient basis for the verdict? Did Gashard make mistakes? Did Judge Downs make mistakes? Prison's bad. We can, if that's what we're going to explore now, you don't need to spend time helping me understand that there are other places Mr. Singleton would like to be.
So even with you acknowledging prison is bad, then by that I'm assuming acknowledging that bad things happened to Mr. Singleton.
They could well have, but I'm not understanding the relevance to a motion for new trial.
It's all intertwined. A parole board that's not going to grant parole. A prison.
So a motion for new trial isn't going to be granted because parole doesn't do what parole does. This is an attack on the proceedings that occurred in this building in 2021, whenever the trial, 2001, whenever the trial was. Not parole board did this, Dooley State Prison didn't do that. Those might be habeas challenges. There might be a mandamus to be brought against pardons and paroles. But motion for new trial is there was a defect or there were defects in the trial. This one has one unique caveat to that, which is nothing happened since the trial and 20 years passed. And that's the speedy trial on the appellate side that we'll work through. But otherwise, we're losing focus on what happened at the trial, what did Gashard fail to do, et cetera. And whatever your view of Gary Gashard, the fact that life was bad in prison for Mr. Singleton isn't, I don't see the relevance to a motion for new trial.
Can I make an offer of proof?
You can tell me how it's relevant.
It's relevant because of all of the above. The prison system, the parole system, and the conditions in prison for specifically this person here, what he experienced, what happened to him.
What makes that, and assume all those things are bad, that it's been bad. How is that relevant to a motion for new trial?
Again, the cruel and unusual punishment argument that we have in our motion.
And I guess because I haven't read all 51 pages, can you distill that down to what the motion for new trial argument is, as opposed to a constitutional argument in front of the Supreme Court that will be rejected, that a life sentence for a party to a crime is inappropriate or unconstitutional?
As I learned as a judge, prosecutor, and defense attorney in Michigan, sometimes you need to put all of the issues in there because down the road, there may be a court that agrees with you.
Okay.
Let me look to try to
I
address
think you've been reading the current Supreme Court's opinions, but
I wish.
I'm wanting to keep us focused on things that I might be ruling on when addressing the motion for new trial. Because if the sentence is legal, then there could be, I guess, an Eighth Amendment claim, but that's really going to end up in the lap of the Supreme Court.
Okay. So in my amended motion for new trial, it's under issue number 4, page 16. And we talk, first of all, using Defense Exhibit A, that is a low risk for future violence, serious physical harm, and the insight he has into his life. Then we also ask the court to take judicial notice of the conditions and environment in the prisons in Georgia. And then we also talk about the physical and mental abuse that he suffered in prison. And that's what I was trying to ask him here. And then I make reference to Graham versus Florida at 560 U.S. 48, where the United States Supreme Court provided assistance and direction for the court. And then also a lifetime in prison is a disproportionate sentence for all but the rarest of children, those whose crimes reflect irreparable corruption. And then we talk about the proposed Exhibit S, the people that are serving life prison sentences, those that have died, the minimum people that have been released. And then we talk about his behavior as a just turned 16-year-old. We talk about House Bill 582, and that this then should be a factor for the court's consideration. And then we talk about that he never intended to kill or hurt anyone. And then also that using a Michigan case, sentences of life in prison with the possibility of parole can be cruel and unusual punishment. And then we talk about the real world result that his verdicts then and now constitute cruel and unusual punishment. And Gashard provided ineffective assistance of counsel by not investigating, not pursuing this via a motion or its sentencing, or using an expert or the juvenile behavior expertise of his second chair. And Greenberg likewise provided ineffective assistance of counsel by not even considering or pursuing this on appeal. And with that, I can move on.
Thank you.
Okay, let's talk briefly about Fulton County Jail. Obviously, the preference would be to have you here in court. Why don't you want to be in Fulton County?
Objection and relevance.
What's the relevance to, I'm in a better position to take judicial notice of life in the Fulton County Jail. Also not a place where I'd want to spend a lot of time. And in fact, your client's not spending time there right now and hasn't for 20-something years. And if he were 16 at the time, he spent 0 days in the Fulton County Jail. I don't want to say 0, but he would have been at a youth detention center.
What I was going to ask him about, or he's going to talk about the trauma with the Atlanta Police Department physically and mentally abusing him.
Okay. This would be after he was arrested for the crimes charged?
Yes.
Okay. All right, that's in your motion. I'll take notice of that when I work through your motion.
Okay, thank you. Do you know if a grand jury was used in your case? What, if anything, can you tell the court?
Objection.
Before you answer, let's work through the, I'll take judicial notice of the fact that a grand jury was used. There is an indictment. It's not an accusation, it's an indictment. That I know is in the docket. So there was a true bill, so a grand jury was used.
So why then can I ask him?
What's the relevance to the motion for new trial?
It's what he found out, what he believes he learned, what we have tried to learn.
And I would add objection to hearsay at that point in time.
Yeah, how would Mr. Singleton know anything about grand jury, anything other than maybe he read the indictment, but that's in the record, or someone told him? He heard someone say, it was a good grand jury, it was a bad grand jury, it was a funny grand jury.
Well, I think you're better able to respond if you allow him to answer and then find out if that's relevant or not.
But if his answer is hearsay, one of the objections was hearsay. So we got to clear both the relevance, I don't know that we've cleared that, and the hearsay threshold. So if you can proffer to me how Mr. Singleton knows anything about what a grand jury did or didn't do in this case that's not hearsay, we can explore that.
Is there anything you can tell us about the grand jury that's not hearsay? What, for example, what somebody else has told you?
I think the hearsay thing is kind of a twist based off my studies. Now, I can't say where my studies led from because that would be hearsay.
Right.
But
so I don't think, and I want to be clear, Mr. Singleton, I'm not trying to prevent you from talking about things that it's appropriate for you to talk about, but I'm still struggling as to the relevance of the grand jury here, other than that they true billed an indictment that this state had to prove beyond a reasonable doubt. I mean, they've been out of this process forever, unless there is some defect. There were only 6 grand jurors, but that is not anything you need to worry about. Your lawyer would be navigating that, and that doesn't
Mr.
require his.
Armstrong denied our request for the information.
What information?
Grand jury.
But what information about the grand jury?
Everything you had.
What information would the state have about, you wanted like the dates of birth of the grand jurors? I'm not familiar with inquiries about grand juries.
Okay.
So I don't know what you asked for.
Let me get back to that, but let me first, what is the relevancy of the grand jury, Mr. Singleton? Why is that an issue for you?
It was an issue for me because during the Paul Howard administration, when I caught my time, I learned that.
Objection, Your Honor.
Stop. Okay, so we're back to hearsay.
but you're asking him what the relevancy is.
You can tell me what's relevant. He doesn't need to testify about what someone told him or he read in a newspaper or an inmate said, let me tell you what Paul Howard did with the grand jury.
That is the relevancy because it's our understanding from what little we know, believe, or have been able to find out is that it may not have been a real per se grand jury that did the indictment.
Okay, and tell me, please, what you mean by a faux grand jury. Because this is not going to be Mr. Singleton's space. This is going to be a legal argument that you're making with evidence that you obtain.
Question was about a special presentment. Where the special presentment means the district attorney speaks and that's it. And then there's a blank version of the indictment.
This sounds like one of the things that rattles around with the jailhouse lawyers. We get a lot that where are the minutes of the grand jury? No such thing. Did you use a special presentment or an indictment? What's your basis for being concerned about this? If it's legitimate, we need to work through it, but I'll tell you, this bubbles up from someone who's been in for 20 years and say, I'm going to throw another stick of chewing gum at the wall to see if it sticks. And I don't want to preclude you from making arguments, but there's got to be a good faith basis for launching something like that, which to me is very different from Mr. Singleton had a pretty bad childhood and that affects his decision-making process.
It's back to what I think you've already been told about that person that he met in prison that used to work in Fulton County. He's the person that told him about
the crooked lawyer.
Your Honor.
But if you say crooked lawyer, then you got Mr. Gashard, Mr. Greenberg, Ms. Roxon.
Okay. Mr. Armstrong.
The testimony was very clearly that it was a city court individual, not somebody who deals with felonies that would have a grand jury.
Right. It was a municipal court, someone who ended up in state prison, which is pretty different from any other names mentioned. But why don't you tell me what you think happened, and then I can tell you if we're going to explore that at all.
Because I don't know. I only know what's been said, that this other person who would have access to the system that I would not have.
Wouldn't, because if it's a municipal court employee, he is talking way out of school saying, let me tell you what happens in Superior Court. He wouldn't know a grand jury if it bopped him on the nose unless he got indicted for something that sent him to state prison.
So people don't talk at lunch or here and there. There's no gossip in the courts.
So
not Michigan.
Lots of people yammer municipal courts way over there, and that is a very different circle of litigants and defendants and judges. I'm not saying that they don't meet each other, but it's a very different process. And we're all into hearsay now anyway. You got a convicted someone telling Mr. Singleton, hey, let me share this with you. You know that's not the basis. If you can develop something, then we should explore it.
That's our point. One, he would have contacts. And just because he's in that court doesn't mean he doesn't know anybody in Superior State or whatever other court.
Nor does it mean that he does.
Also, Your Honor, double hearsay, because he's saying this person learned it from somebody else.
Right. Let's move on to another topic. If you can lend some shred of credence to this beyond a convicted felon in prison told Mr. Singleton about it, then we can explore it more.
Even though Mr. Singleton has already testified that they did have some documentation, but that didn't end up being destroyed, lost, whatever, when they had the riots.
It's convenient that that's what happened to it. So let's press on.
That sounds a little not like the judge I know.
Sounds like what I'm hearing more and more from Mr. Singleton, that I used to have it, but I just can't put my hands on it. But the convicted felon is the guy who told me about it.
And with all due respect, if you were lost by the system for 20-some years, you probably would want your day in court too.
Mr. Singleton has had many, many days in court, and we have gone way off the reservation by having this discussion about special presentments. So if you want to arc back to evidence, let's talk about that.
Okay, I will rely on the evidence we have presented.
All right.
What can you tell the court about Michael Waters when all this happened? What was your relationship with him? What was he like?
And when we say when all this happened, meaning the shooting of Sergeant Grigley?
Yes, the
okay.
time frame.
Objection, Your Honor. This sounds like it's time to elicit character evidence.
What's the relevance of Mr. Singleton's opinion of Mr. Waters at the time?
Mr. Waters was older. He was the leader. Mr. Singleton went along maybe with things he would have done today. To me, it's completely relevant to show you the not only the what, but the why, what happened.
It's not my role, though, in a motion for new trial to say, gosh, if I were a juror, I might have done this a little bit differently. I know I sit as the 13th juror, but that's a different standard than Mr. Waters was the leader or not the leader. And I mean, you've read the trial transcript. I don't know that Mr. Gashard made Mr. Singleton sound like the leader and Mr. Waters the follower.
Or maybe Mr. Gashard should have pointed out that Mr. Waters was the leader and Leslie was only this kid following an older kid.
How old was Mr. Waters at the time?
I think he's around 2 or 3 years older.
Okay, so he was a whopping 18 or 17, but older.
Yeah.
Okay.
And I can certainly tell you the difference between our 6-year-old granddaughter and her 9-year-old sister.
Okay.
Did Gashard ever give you copies of Mr. Waters' statements?
Gashard, no.
Sorry?
No, sir, not Gashard.
Did he ever discuss with you the inconsistencies in those statements?
We never had conversations like that.
What kind of conversations did you and Mr. Gashard have?
We had conference room conversations. When they called me to court, right before we went into the room, that's when we talked. And it was basically about, oh, this is going to be about this or that. You'll have to sign this. And I'll ask them a question about what I'm signing. But there was no, you know, I can say that now, but there was no conversations in depth about the case. Reading statements with me, reading evidence with me, going through my story with me. It was based off of, you know, we talked during the conference room, right outside the courthouse in the conference room. We'll talk, then come in, leave, and we'll do it again the next time.
Ballpark, as best you remember, how long would a conference room conversation go?
Fresh out the holding cell, probably 5-7 minutes.
And is that the extent of your interactions with Mr. Gashard, other than when you were sitting in court for trial, would be a collection of conference room conversations?
Holding cell, you know, like before they take me to the conference room, talk behind the glass.
Mm-hmm.
But it was that's one time he came to the juvenile facility, and that was, you know, during the incident, when the incident occurred. But after that, there was no on the conference rooms.
When you say the incident, what do you mean by that?
The incident when I had told him about what the police did to me when they was taking me out of the jail.
Okay, got it. And he came out to the YDC to talk to you after you told him that that had happened?
Yeah.
Okay, how long was he out there to meet with you?
I really can't say the you know, right amount of time, to be honest, but I really don't know. I can't recall.
Okay. But most of your interactions with Mr. Gashard were what you're calling the conference room conversations just before you were coming into court, and they were typically less than 10 minutes.
Facts.
Did you ever have a conversation with Mr. Gashard where he said, look, this is my defense for you. I'm gonna argue this. What do you think about that? But I've looked at the case and this is our best shot. It's gonna be, I'm making it up, alibi, you weren't there, or self-defense, or we gotta put it all on Waters and you gotta admit you were there because he's gonna put you there, but we're gonna try to minimize your role. Did you guys ever have a conversation about game time strategy?
We had a conversation that I know vividly, was during the day that Mike was supposed to take the stand. And during that time... Wait.
So let me stop you. So this is after your trial has already started?
Yeah, it's after the trial started.
All right, so I asked my question poorly. Before your trial started, before the jury's been selected, all that kind of stuff, did you and Mr. Gashard ever have a conversation about his plan for your case? Let me tell you what to expect, Mr. Singleton. This is where I'm going to argue. It's going to be self-defense. I know it's not self-defense, but it's going to be whatever it is he said. Did he have a conversation with you about what the defense was going to be, how he was going to make your case?
Defense strategy, no. Pleading out, yes.
He talked to you about trying to plead out.
Yeah, majority of the times when he came to see me during the first parts before trial was to find out who the other two guys that I was lying about. He wanted to know, trying to get me to, say who they was, and you can get out by the time you're 21. And mainly it was about trying to get information as to who the other guys was.
But the other guys were people that you made up?
Other guys were two people I substituted for, yes, I made up. Okay.
After it became clear that the defendants were the three of you and Waters and Merez, did Mr. Gashard ever talk to you about trying to work the case out?
No. Once he found out that I lied about who the people was, I was covering up for, who my co-defendants was, that's when he became, that's really when I feel like he wasn't my lawyer no more. There was no working it out after that point.
And tell me what you mean by he wasn't my lawyer anymore, because Mr. Hort alluded to that long ago. You've been listening to testimony for a long time, and this is bringing it back. He learned you lied. He's mad. He's not your lawyer anymore. And how does he manifest that? Does he stop talking to you, or when he talks to you, he says, "Screw you! You know what? You lied to me, so I don't want to talk to you."
We can say this, and I asked my lawyer, could I speak on that, because he's deceased, and I don't want to make it seem like how you were saying you're trying to stick something on the wall when these are grounds that took place decades before a motion new trial even was manifested. But the things he said, once he found out, it said that he wasn't on my side no more, and that was verbatim, not verbatim, I'm gonna paraphrase it, but when we came to the conference room and he found out that the day that, everybody found out that these two were the guys, he said he was just yelling at me and, real upset, and was saying that I wouldn't have to worry about the police because he'll do it himself. And if I ever lie to him again, that was his exact statements, and this was verbatim. And at that point, I can't say that I knew, but when I retrospect, I realized that it was nothing else done. It was nothing else done, and I believe he felt some type of way because I did lie, and I did, I misled him in regards to who the co-defendant was. And every time he tried to, work a deal or, bring the detective down, and when he used to talk to me and whatnot, it was always that conversation of me trying to tell them who the other two people was. And once he found out I lied, then that was his response to me. And that was the last time it was ever a real, it was anything outside of the conference room.
Okay. And again, you've answered this. I just want to make sure I got it right. After that time, there was no conversation you had with Mr. Gashard before trial about strategy, about what the defense is going to be, anything like that?
That didn't exist.
Okay. Then I interrupted you. You said just before Waters was going to testify, you guys did have some conversation about something. What was that?
Okay, that's good. You came back to that. Right before Waters testified, and this was, I can't say if it was at the table or we was in the conference room, and I'm thinking the conference room, but he was saying me testifying would be dependent on if Mike testifies, if he agrees to testify. Everything was dependent on if Mike testified. If Mike testified, you would have to do this. If Mike testified, if he doesn't testify, just chill. But yeah, it was everything was predicated on if Mike testified, if he would follow through with his testimony.
Okay. And when you say follow through with his testimony, you mean testify consistent with what? Or just that he testify at all?
Testify consistent with the state's theory.
Okay. And did he?
He did testify.
Okay. Well, I know he testified, but it apparently was consistent with the state's theory?
It was consistent with the theory that I told him to do it. I provided everything for him to do it. I was the person who made him or told him or however. I was the orchestrator of everything, and he was just the, do what I say guy.
Okay. Any strategy discussions or tactical discussions? Hey, here's what we need to do. Here are my thoughts after Waters testified.
No, and it's actually on record when Judge Downs addressed that because after the trial, after the testimony, he just, it was over with. He went his way, and before he left out, the judge stopped him and was like, "Hey, aren't you gonna do this? Aren't you gonna do that?" She checked him on the spot, and he was like, "Well, I was gonna get to it when." She said, "No, we'll do it now," and she made the docket in court about my appeal and what was next. But he just went on his way, and she stopped him at the door, and there was nothing after that. I haven't heard from him, gotten a letter, gotten a no direction, no nothing. Skeleton brief, I guess, on the appeal. I don't know for sure, but
what kind of conversations did you and Mr. Gishard have, if any, about whether you're testifying?
My testimony was, according to him, and this is, again, he's deceased, but he was telling me that this is his exact words, "We need the sympathy of the jurors." And he wanted me to demonize Mike just a little more, for example. And I couldn't do it. I couldn't do it like he wanted me to do it, even though, the question he was asking me was the trigger to say this or that. But he wanted me to say that Mike put the gun to me, like pointed it my way and said, "Hey, get in the car." That was his exact, he wanted me to say that to make it seem like I was forced in the car. But I was like, I couldn't do that. But at the same time, I was stuck in between what I wanted to do and what I wanted to look like. So that was his strategy for me, to prey on the sympathy of the jurors and to make it seem like Mike forced me to do it when that wasn't the case. There wasn't a forcing to do anything. You feel what I'm saying? So that was where there was no harmony in that either. He didn't want to go with nothing else, but you got to make it seem like Mike did this, or Mike told me to do this, or Mike pointed the gun when he said get in the car. He just didn't ask you, he pointed the gun at you. Mike threatened to kill you if you snitched. All of those stuff, that was not, that was the strategy.
Okay. Back to you.
Thank you. So then, did he tell you to lie at the trial?
He most definitely did.
And did Gishard ever threaten himself to kill you?
Get me was his words exactly, and I might be being euphemistic, but he was saying how when I reported what the police did, he used that back in saying, "You don't have to worry about them doing it. I'm gonna do it myself if you lie to me again." And I know what he meant, because of what I told him with the incidents with the police when they was taking me out of juvenile.
Were you ever given the opportunity to correct your statement?
Never.
What statement are we talking about correcting?
That's him.
Go ahead.
No, and what do you think Mr. Hort just asked you about? What statement was it that you were supposed to correct, but you weren't given an opportunity?
The first statement I made, the lie about CJ and Rod, that's what was held. That's what's still today hanging over my head as well. You lied on the statement. Everybody in the case lied in their first statement. I was the only one not allowed to make a second or a third. So yeah, that most definitely was an issue, and I never got an opportunity to say, okay, I lied, but this is why I lied, or this is why I did that. Everybody else made 1, 2, 3 statements, and this was one that was binded to me throughout the duration of my case up until right now at 41.
Did Gishard ever talk to you about what Waters and Morez did afterwards, any of their actions? Was that ever discussed with you?
Afterwards, meaning after they pled?
No, after the murder and everybody runs away.
No, Gishard, no.
Why was that important?
For me, everything came from discovery, but it was important for me because after the incident, David and Mary stayed together. And when they found out that and this is what okay, again, that would be hearsay, but they stayed together and their story was in harmony because they believed that I was telling on them, that I was the snitch. They didn't know Mingo was the state's witness. They thought I was. And with that being said, the first thing on everybody's statement was, Leslie was doing this. Leslie told me this. We didn't know anything about it. And that, that alone shows that their statements was in sync until, you see a few inconsistencies in everybody's statement, but that was what was important. After I left and chose to go to the Dave's mom house, and they chose to go themselves, that was the whole vibe. We never spoke until the night that I found out that they told me that what happened.
What about them changing their appearance?
They changed their appearance based off what they saw on what they was hearing off the news. The news was narrating that I said.
Objection, Your Honor. Speculation as to what somebody else thought and did.
Right.
Not necessarily what they heard, but how did they change their appearance?
They cut their hair. They changed their hair color.
Okay, and I realize you are at coffee, you're not here, so I can't per se give you this to look at, but I would give to Mr. Armstrong. We're talking about the Merez bond motion on September 11, 2000, page 8, and then also the Merez bond motion on November 28, 2000, page 11. On September 11, 2000, the state told the judge the two, Mr. Singleton and Mr. Waters, approached the vehicle. Mr. Merez stays back at the driveway. They order Sergeant Grigley and Ms. Blaylock out of the vehicle and order them on the ground. They're literally laying on the pavement on their stomachs as Mr. Waters and Mr. Singleton get into the vehicle. On November 28, 2000, the same state attorney told the court when they stumbled upon Sergeant Grigley and Debbie Blaylock arguing, it was Michael Waters who said, "This is our chance." And Michael Waters told the other two to wait in the driveway while he went in and perpetrated the crime, which you've heard about many times at this point, which you won't go back into. Did Guichard ever look into or talk to you about the difference in what the state's attorney said at these two bond hearings?
No, never exploited any inconsistencies in any statements because there was no statements that me or my family saw until after trial, after the discovery package through it was actually through Clayton County because Clayton County's case was just the files of full county statements, and that's how we got all the files at one time.
Did Guichard ever talk to you about using this inconsistency by the state's attorney at the trial?
No, sir.
Did Greenberg ever talk to you about any of this?
Most definitely not.
Your Honor, I have a very strange question because we're about to have to conclude.
Right, our Zoom ends in 11 minutes.
Mr. Singleton testified about a diagram that has now been destroyed and everything like that. I wanted to share screen and see if one of the materials that I turned over to Mr. Hort as being in the trial file is that material, because in the interim between today and whenever the next day hearing is, Mr. Hort might want to look at it.
Okay, this would be a diagram from the ME's file is what I was remembering.
Correct.
Okay.
It is in, I can't figure out how to share screen at this moment. I apologize.
Okay, you just bring it up and have Mr. Singleton look at it?
That's what he's trying to do.
Oh, I'm sorry.
That's the share screen part.
Mr.
Success.
Waters, is this the diagram you're referring to?
Mr.
Singleton.
No, sir. No, that's not the diaphragm. The diaphragm would, you see number 1 where it outlines the body? The diaphragm is a big, half of the page is that. And then you have this as a smaller version, but not necessarily the roll. It just shows the shell casings being circled, and the body is half of the page. And they show an arrow where it went in, they show an arrow where it exited. And yeah, that was the page that I'm looking for.
It's interesting that that's in the, I've never seen a page like that in a medical examiner file anyway.
I don't know if it was with materials, so it's basically whoever made the trial file possibly put it in there. It might not have been the medical examiner, because the medical examiner's report has page numbers.
Right, but it does say ME 23 pages, but who knows?
Well, that was my writing about what I found in the binder.
Okay. All right, so not it. Thank you for trying though. Mr. Wirt?
I'm sorry, did you want to keep going or what's your?
Well, you have a few more minutes. I'll pause us with a couple minutes left just to wrap things up. But if you have a discrete area you want to cover, let's do that.
Okay. So I'm going to give to Mr. Armstrong on the Singleton bond motion, page 15, that motion being on November 15, 2000. At your November 15, 2000 bond motion, the state's attorney told the court Leslie Singleton actually was going to drive the vehicle away from the scene, at which time gunfire erupted between Michael Waters and Sergeant Grigley. They abandoned their plans because Leslie Singleton was actually shot in the arm by Sergeant Grigley in the return fire. And then I'd make reference to Defense Exhibit Y. In his November 28, 2000 statement, Waters said, "When I went to the car and got everybody out, Leslie came back and got into the driver's side, and I went around to the passenger side. And I don't know what happened, but Leslie was like, 'Let's go. We don't have to get the car.' We were about to dip, get out of the car, and the officer jumped up and started shooting at."
He just blanked from the screen. Everybody lost sound.
All right, you should be able to hear us again. Can you hear us?
Good.
All right. Ms. Rivers, what was the last thing you heard?
In 1 moment. Mr. Hort was saying we're about to get out of the car, and the officer jumped up and started shooting at, and then the sound went out.
Okay, sorry about that.
Okay. So again, referring to Defendant Exhibit Y, and the officer jumped up and started shooting at us, so I just shot back. That's Waters in his November 28, 2000 statement. Did Gishard ever talk to you about the difference in what the state attorney said at your bond hearing and what Waters said on November 28, 2000?
No, sir. I really didn't see it until you brought it to my attention.
You were not shot by Sergeant Grigley in the return fire.
I was shot by Sergeant Grigley, yes, sir.
But not in the return fire. Sergeant Grigley shot you first.
Yeah, Sergeant Grigley shot first, and then, Mike shot, and that was the part that I was hung up on.
And also, your abandoning the plans took place prior to you even being shot by Sergeant Grigley.
Objection, Your Honor.
Stop, don't answer yet. What was the objection?
Leading.
Oh,
Yes, it was. And I'm trying to get our last couple of minutes in here on this topic.
Okay.
I'm trying to bring out that.
I get it, because you could, that's a question that can easily be asked in a non-leading way, and
Okay.
so it's okay. I just go ahead and answer the question.
Before there was even before he even came to the car, back to the car, I was already stressing, let's go, F the car. And I'm without saying the words, we're arguing about me driving the car now. We're in the car for at least 60 seconds. We're in the car arguing. He's telling me to go. I'm telling him, F the car, we can just run. F this. And at that part, when I looked in his eyes, I seen that he was seeing something, which made me turn that way. And now I'm trying to run out. But I was boxed into play. Before he even jumped shooting, we already was screaming. I was already screaming, let's run. It's just so happened he shot us. He shot me before I could make that happen.
And we'll talk about this more in detail. I just wanted to ask you, did Gashard ever talk to you about the difference in what the state's attorney said versus what Waters said?
No.
And
again, I know that when you told us.
To your knowledge, did Gashard ever look into this or talk to you about using it at trial?
Never.
Do you know why Gashard didn't use Waters' November 28, 2000 statement at the trial?
Why don't you ask, did he tell you? Because otherwise he's guessing.
Did Gashard ever tell you why he didn't use Waters' November 28, 2000 statement at the trial?
He never did, no, sir.
Okay. And Your Honor, that's about where I switch now to a different topic.
Okay. Do we know how many rounds Sergeant Grigley fired? I don't know if he had a revolver or a pistol.
I have not had a reason to remember.
I'm not asking you,
okay,
Mr. Singleton, the two lawyers.
I believe that information would be in the record, but it's not something that I ever.
Okay.
I would agree.
Got it. All right. So this is a natural break point. They're about to pull Mr. Singleton from the room. We need to line up another hearing. How much more time do you think you need for your direct examination of Mr. Singleton?
I am going to guess 2 hours.
Okay. So if we get an afternoon or a morning, sort of a 3-4 hour block, that should be enough for the direct.
Right.
Any sense of how long cross will be? I know you haven't heard the rest of direct.
I imagine it'll be less than an hour.
Okay, so we ought to, with one more session, be able to get through all the evidence, unless you've got other witnesses.
Well, I would ask, and I agree with Mr. Armstrong that he's entitled to 10 days. So I would ask that you not set it earlier than 10 days.
It won't be. I have trial the next 2 weeks.
I would ask that the changes that have been added, I would ask that we start putting them in a separate document that's not inserting them.
Yep.
Because it's very hard for me to go through 51 single.
I don't even try. That's equivalent of about 150 pages. And it's from now on, if you're adding something, it will be sixth now. The sixth amended motion for new trial should only have in it that which is new.
Well, what I tried to do in accordance with your comments/directions was to give you what is our motion all about. So I deleted some things that I didn't feel were important or that you wouldn't find important. And so I put in there only what I want this court to consider in deciding this case.
Okay. You left me with 51 pages, so it's plenty. But to Mr. Armstrong's point, it's hard to tell the parts that are new. And it may be that there's much that's new throughout because you gave it some nips and tucks. But you also dropped in, for example, House Bill 582, whatever the number is, which is perfectly appropriate, but it doesn't jump out at anyone. And so my request going forward is if you have another amended motion, if you have amendments to the amended motion, to say, here's what I'm adding. Paragraph 1, 2, 3. And by the way, I removed paragraph 841 from the fifth amended.
I can do that. I don't, knock on wood, plan anymore. And I also would suggest that you can disregard all the prior ones.
So
Only
5
issues-
supplants all the previous ones.
Yes.
That's good to know, but it still doesn't address but wait, what's new in here? But what Mr. Armstrong doesn't need to worry about is, well, let me look at 3. I want to make sure I'm not missing anything there. 1 through 4 can go out the door.
Yes.
Okay. All right. Mr. Singleton, any questions?
No, sir. Enjoy your weekend.
You too. Mr. Armstrong, anything else?
Yes, Your Honor. As I previewed
Hold
in
on.
the,
Let me mute that. No, it's good. We're back. I don't know if your camera's on. Don't worry about that.
so, Your Honor, yesterday I filed a certificate of discovery saying what I had previously served to Mr. Hort about the trial file and about different transcripts. It doesn't include everything I've ever done, just those discrete things. And so I suggested potentially adding that to the record in the sense of not just showing what was served in discovery, but also Gary Gouchard would have seen all of these things. We don't have to have this individual document or this page of this document. If we just add all of it, basically, Gary Gouchard would have seen all of that. What would a reasonable party have done with that information? And so I have...
Assuming he looked at it.
Assuming he looked at it.
Right.
What a reasonable person would do given that information. I have 4 copies, 1 for the court, 1 for Mr. Hort, and 2 for the clerk, or if that's what the court prefer. Otherwise,
Sure.
I'll just do the certificate of discovery and say this is what I've served.
I'm open to either one. If you've got a preference, or if you've got a preference, Mr. Hort, we can, if they're aligned, we'll just do that.
My concern is twofold. One, do we even know whether Gouchard got all of this information? I mean, we do have what's in the Tyler Host online as to certificates of discovery filed by Sheila Ross, but I don't know that that necessarily correlates with everything Mr. Armstrong is saying today that Mr. Gouchard would have received back then.
Well, we'll never know for sure, because it could say on a certificate of discovery, we gave him 6 police reports, and maybe 2 of them they meant to put in, but they slipped out. So there's that, coupled with, we don't know that he ever looked at it either. We have to use some yardstick of, it appears this is what was produced in discovery. But there'll always be that caveat of, you don't have his file. And so you don't know what he got, and we don't know because he didn't get a chance to sit right there. What did you look at?
And that's why I guess my preference, I have no objection to the court receiving it, and thank you for a copy. But I don't want any implication that indicates that Mr. Gouchard had it.
Okay.
You know, we found some things that Leslie didn't get until post-trial, so I don't know if that means Gouchard didn't get it either. I don't know.
All right. The fact that your client didn't get something from Mr. Gouchard, to me, isn't very probative of whether Mr. Gouchard had it, given the description your client's given of their relationship.
Then I also have a concern, Mr. Armstrong's also referencing emails. And I'm not completely sure what emails he's talking about. He did give me an email response back, and I found some emails on March 5, 2024, but I'm not sure the relevancy of these emails, why that's included in this, what do you call it?
They are showing that they literally include the attachments themselves and show that I emailed each of those to Mr. Hort.
Okay. Let's go forward and make it part of the record. It's just easier that way. It does not create a presumption that Gouchard had it, or more importantly, that he relied on it and discussed it with his client.
That's fine.
Okay.
Can I provide the 2 copies for Ms. Rivers since we're doing it that way? Can I provide that to the court?
Say that one more time.
So if we're adding it to the record in that sense, Ms. Rivers, as the court reporter, would be the best person to certify it. Can I leave her 2 copies with Your Honor?
Yes.
I'm marking those States Exhibit M&T1.
Got it.
And if I can ask, then when I get this copy of this exhibit, I'll be able to look and see what the emails were, look and see what the things that you've attached are. They'll actually allow me to click and look.
Occasionally they'll say it's too large. For some reason, there's 2 versions of Outlook, and when I said open with and picked the first one, they would open up the ones that were too large after they got saved.
And
If there's something you can't, Mr. Armstrong will get it for you.
That's because in fairness to Mr. Armstrong, based on his emails, I was able to verify almost everything that he's already referenced in the disc or in the emails.
Great.
Just one or two that I have some questions.
Okay. While you are all here, Ms. Hansberry, even though it's after 5 on a Friday, is flagging some windows of opportunity when we can get everyone back here. Looks like it's going to be the afternoon of September 4th. Well, I want to make sure that works for both of you before we lock it in.
Yes, it looks fine for me.
I do not have anything there.
Okay, great. It is tentatively set for 2 o'clock on September 4th, but we'll get notice out and we'll make sure that works for GDC as well. Thank you, everyone.
Thank you.
All right. Thanks, DDC, for getting Mr. Singleton there for so long. Take care.
These are 4 exact copies, just pick whichever one you want.
Oh,
So it shows that I'm not picking which one to give to the court.
I want the 3rd and the 4th.
well, the one actually has the on it, so I'm thinking that's probably meant for me to take that.
Thanks,
No,
Ms.
they all have it.
Rivers.
They're just
I know,
fixing
I
it.
just